And as a reminder, as we pick back up where we left off, we are in the comments of the license law and commission rule. So there's license law, and then there's commission rule. And the comments kind of summarize the bigger points, the bigger pieces of it. So the comments are where the majority of your state-specific exam is. There is some state stuff that's not in the comments that we will pick up at the end. Of course, make sure we cover it all. But the comments, guys, be very honest with you, across the state, it seems to be that the trend is when you go to your state exam, if you're going to pass a section and fail a section across the state, it's passing the national and failing the state section. So the question I get is, how do we know what to study for our state-specific section? And the comments are the first place to start because the majority of that section is here. You'll also remember, scattered throughout your book, we talk about things that are specific to North Carolina. So we talked about the North Carolina Residential Rental Agreement Act, for example. Whenever you see in North Carolina in your book or your PowerPoints, little state flag, then that's an indication that that too is a state-specific section. So we're here, good morning. So we're here, and we're gonna pick back up where we left off, not this section out. Remember too, guys, I get it. How many of you spent all dang weekend studying? Every waking moment of the weekend. See, I know you guys. So, okay, good. Some of you went and had fun too. Good. I get it, you guys. You've been studying, if not all weekend, at least some. Good morning. And there's a really good chance in this section I'm going to say something, and it's going to make you think of something that we talked about previously. It's going to trigger something in your mind, and you're going to be tempted to ask about something that we talked about in Unit 3. And this is the section I have learned that I have the hardest of keeping us on track, keeping us on point. So the best way I know to do that is to encourage you guys to have a scratch piece of paper next to you. And when you have a thought enter your brain, jot it down. So after class, you can either go look it up or reach out to me and let me help. But during class is not when I can cover it because we got to stay focused here. We got to stay on track. So to have everybody on the same track or the same train as me, awesome. I want to answer your questions, but we got to focus on this. Again, the state specific is, it's the harder of the two sections to pass. So with that being said, another thing I like about the comments so much is so much of this is a review. And when we're getting into the state specific section, we're reminded of dual agency. Now, dual agency, some states offer dual agency, other states don't. That's why it's specific to North Carolina. We don't need to know which states do and which states don't. All we care about is this is how we do dual agency in North Carolina. And the simplest definition, the simplest form of dual agency I can offer you, dual agency is an in-house transaction. In-house transaction meaning, everybody show me how many firms, you guys are ready for me. In-house means we're all coming from one firm. So one firm, two clients, same transaction. The seller is selling 123 Main Street. The buyer is buying 123 Main Street. Dual agency can be two brokers, one working with the buyer, the other working with the seller. Dual agent could also be one broker. It could be single agent dual agency, in which you have one agent working with both the buyer and the seller. Always remember, dual agency is about the firm. Why don't you write that down again? Dual agency is about the firm. It's about who the firm represents. And we see our little dual agency wall, our agency wall. I got the buyer hanging out. I got the seller hanging out. I got the firm and all the agents in the firm straddling the wall, representing both parties to the best of their ability, as best as they can without compromising the other. With dual agency, advocacy goes away. There is no piece of advice that I can offer my buyer that won't harm my seller. If my buyer wants to make an offer less than asking price, isn't that harming my seller? Because my seller wants to make X amount. What if my buyer wants to offer more? If I tell my buyer to offer more than asking price, could I be harming my buyer? In all my years, you guys, when it comes to real estate, when it comes to this transaction, I have yet to come up with a piece of advice that I could offer one that doesn't harm the other in this transaction. And that's what's up with dual agency. In dual agency, that advocacy goes away. Remember our football game is our analogy. Prior to dual agency, we're coaches. We're standing on the sidelines. We're not telling them what to do because we can't, because we're special agents, but we are shouting our advice. We are offering our opinion. And I can do that as a coach. Once I enter into dual agency, I'd switch from being a coach to a referee. And now I can no longer offer advice. I can no longer offer that opinion. The other thing to remember about dual agency, it's about the firm. So if the firm has multiple locations, it's still about the firm. You could affiliate with a firm that has 3 locations, and you could be in dual agency with an agent at another location that you've never met, possibly, because it's all about the firm. The firm has a duty to treat both parties equally and loyalty, and they cannot offer advocacy. A potential solution to dual agency is designated. Designated is a form of dual, which means we have to have the parties agree to dual before we can designate. The other key to designated, the firm has to provide it. The firm has to offer it. Designated is not mandatory. Firms don't have to offer it. For your exams, don't assume we're offering designated dual agency. I need you to see it. Head bobs, everybody heard me? Don't build it in if it's not there, because it's not automatic. It's not guaranteed. So I need you to see it. So what happens in designated, one agent is kicked off the wall to work exclusively with the buyer, and a different agent in the firm is kicked off the wall to work exclusively with the seller. Designated dual agency is always 2 brokers. That exclusivity comes back now that these 2 agents are designated. These 2 agents' role is going to change once again. They were a referee with us, the rest of the firm, but now that they've been designated, those 2 agents and only those 2 agents can now start acting like the coach again. They can offer advice because they've been designated. They can offer advocacy. They can advise their client through the transaction. Check out the firm and the rest of us. We're still hanging out in dual. Dual agency does not go away in designated. Designated is it's around to allow the firm to offer exclusive representation to 2 parties. That's the whole reason why we have designated. And there are 2 big caveats with designated. You can't be designated if you come into this with prior information about the other side. So let's say you're the buyer's agent and you've been working with this buyer, you've been showing a property for a couple of weeks, and all of a sudden they're interested in something that your firm has listed. Your BIC or somebody with power in the firm should be asking both agents prior to designation, do you know anything about my seller that could harm them in this transaction? And then they go to this agent and they say, do you know anything about my buyer that could harm them in this transaction? The agents can't have prior confidential information about the other side prior to designation. Once you've been designated, if this buyer's agent learns anything at all about the seller, they have a duty to share it with their buyer. Exclusivity is back. Advocacy is back. Now that these two are designated, they might as well be with two different firms. The other caveat to designated, and the number one problem topic in Unit 7, so let's make sure we're good. The provisional broker and the broker in charge cannot be designated opposite of each other. You cannot kick a PB off to work with the buyers, off the wall to work with the buyers. You cannot kick a PB off the wall to work, or a BIC, excuse me, a PB and a BIC off the wall to work with buyers and sellers. They cannot be designated. Shake your head, yes or no. Can a BIC and a PB be in dual agency together? Herein lays a problem topic. They can be in dual, yes, because dual agency is about the firm. They can be in dual. They cannot be designated. Talking about the single agent, dual agency by an individual. Even though you're a single agent, dual agent, you're representing both parties, that does not give you the golden ticket to tell each other the other's confidential information. So even though I'm in dual agent, single agent, dual agency, I can't tell my buyer confidential information about my seller. I can't tell my seller confidential information about my buyer. OCAR, that C in OCAR is confidentiality. And we're going to still honor that when we enter into dual. OCAR stays in place in dual. The only thing that goes away is advocacy. Technically speaking, we could run around the office or the firm sharing information about our buyers and sellers in dual agency. But what do y'all think? Is that best practice? No. A lot of firms will have policies on that. Remember, you guys, when you get in your firms, when you get in your offices have thin walls. So when you're talking to clients, when you're talking about sensitive information, just be very, 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 very aware of that. Questions about dual or designated? Some more just general brokerage. Again, we're just moving right along through the comments. The comments address when brokers are party to the transaction. Specifically, License Law and Commission Rule says if you are selling property that you own, your name is on the deed either directly or your name is on the deed by way of a spouse. If your name is on that deed and you're acting as the listing agent, you cannot represent the buyer in that transaction. Makes sense. Do we see the conflict of interest? OCAR would say, I have my buyer's best interest. But guys, let's be very honest with each other. If my name is on the deed, whose best interest do I actually have? try as you might, there's a huge conflict of interest there. So when you're representing yourself, when you're selling a property that you own, and you're acting as the listing agent and the seller, you cannot represent the buyer in that transaction. Somebody else in the firm could represent the buyer, but you can't. All good rules have exceptions. The exception to this rule, if it's a commercial listing and you own less than 25%, your ownership interest is less than 25%, you can represent the buyer in that transaction as long as you go into a full disclosure, letting the buyer know, I have a 20% ownership interest. I have an interest in this property. And if they agree, I need you to document that conversation, that you explained it to them before we entered into this relationship. More general brokerage stuff. Once you guys are licensed, you may change your name. Maybe you get married, maybe you get divorced. You may change your address, you may change your firm. You're going to make changes once you're licensed. Commission rule says we have 10 days of the change to notify the commission. Once you guys are licensed, you'll have a licensee login right on the commission's website. So you log into your account, you can edit your information right there. You can keep track of your CE and your post licensing and anything about you as a licensee, you'll have access. So it's really easy. Change your name, address, phone number, and or email. You have 10 days to log into your account and make that change. 10 days. Commission rule addresses advertising. First off, we have said on a couple occasions, I cannot perform a single service for an owner without having a written agency agreement in place. I can't do anything for a seller or for a landlord until I have a written agency agreement in place. Buyers are the only ones that I can work with under an oral agreement at first. BICs are responsible for the advertising that goes out. So when you advertise a home for sale, when you advertise your services, always remember, you guys, whose listing is it? Is it yours? No, it is the firm's. If you are advertising your brokerage services, you are advertising your brokerage services under this BIC. So the broker in charge is responsible for all advertising that comes out from the firm or their specific office. They should be reviewing before it goes out. I mean, y'all, we know how the internet works, right? You hit submit and there it goes. It's out and it's awfully hard to get back sometimes. So having the BIC review it, especially you guys as soon to be provisional brokers, make sure your BIC is reviewing your advertising before it goes out. It's in compliance with commission rule. It's in compliance with fair housing. Once you're a full broker, maybe the BIC still wants to review it. Maybe they just want to check in on every once in a while, but your firm will have a policy on how they handle advertising under their name. And also with advertising specifically, commission rule says we can't have any blind ads. A blind ad is one that doesn't mention the firm. Because whose listing is it? It's the firm's. I can't say Julie Campbell has a house for sale, because guess what? Julie Campbell does not have a house for sale. Julie's real estate shop does. To make sure you're advertising that firm, otherwise you have a blind ad. And this does apply to social media. And guys, I'll be honest, you don't have to go far in social media and find this commission rule being violated. Does that make it okay? It's not a problem until you're caught, right? And then when you're caught, now you got a violation of commission rule, which could be cause for disciplinary action. There was some higher up a couple years ago. There was an agent on social media. I think it was when Taylor Swift or Beyonce were coming to Charlotte. One of those bigger acts was coming to Charlotte. And the agent took to social media, and it was joking, but still, the agent took to social media and said, "Let me help you buy a house so I can afford Beyonce tickets." It was a joke, but were they advertising their brokerage services? They were letting you know they can buy a house, right? I can help you buy a house. That's advertising your brokerage services. That's an ad. And unless you have the firm's name, that's a blind ad. Questions or comments on that? Don't we all want to go see Beyonce? Just send me money. There's a commission rule that addresses delivery of instruments. Who remembers, and you can show me, how many days do we have to deliver instruments? Yep. We have 3 days to deliver instruments. That 3-day clock starts from execution. In other words, when it's signed or when you receive it. So first off, what the heck is an instrument? An instrument is just any document that's related to this transaction. So it starts with our agency agreements. At some point, we're going to have contract paperwork. And then hopefully we'll also have closing paperwork and anything in between. A good rule of thumb, if buyers or sellers sign it, they deserve a copy of it. And there's a common misconception out there that I can wait until the end of the transaction and send everything in a nice, neat package and say, here's all of our paperwork together. But guess what commission rule says? Commission rule says I have a duty to deliver these instruments within 3 days of execution. Either when they're signed or when you receive it, your 3-day clock starts. Does it take y'all 3 days to send an email with a PDF attachment? It's so easy. Here's our signed agency paperwork. I look forward to working with you. Have a nice day. That's all you have to do. If you email it, now you have documentation. You have a date and time stamp of when you sent it. Document every stinking thing. Also note this word says delivery. That's my job, is to get it to them. What they do when they get it, I don't care. They want to throw it away, they want to delete it, makes no difference to me, because my job is just to make sure that I deliver it, make sure that I send it to them. All good rules have an exception. And the exception to this rule are offers. We have a duty to present offers to our sellers immediately, but in no event later than 3 days. We have a duty to deliver offers to sellers immediately, but in no event later than 3 days. Somebody better be, out of touch for a couple of days if we're not delivering offers. Evidently, timely delivering offers is a problem, a persistent problem that the commission hears about. I don't understand. I don't get that. If it doesn't close, I don't get paid. It can't close until it goes under contract. It can't go under contract until I present the offer. Chain of events. Commission rule also addresses how long we have to keep records. Anybody remember how long we keep records? We retain records for a minimum of 3 years. So we keep all records. If we're documenting everything, then we're going to keep everything. What good is documenting it if you don't keep it? The commission says a minimum of 3 years. It is recommended that we keep stuff for longer. But when we're asked about commission rule, They say that we keep things for at least 3 years, and that 3-year clock starts from the successful or the unsuccessful conclusion of the transaction. If it terminates before it closes, that's an unsuccessful conclusion, but that starts your 3-year clock. If it closes, once all activities to closing are complete, once it's a done, that's when the 3-year clock starts. If you have any outstanding promises or obligations that pass closing, that go beyond closing, then your 3-year clock isn't going to start until your obligations, your promises are fulfilled. General brokerage duties discusses our brokerage fees and compensation. If you are going to earn a bonus, if you're going to make more than what we agree to in our agency agreement, I have a duty to disclose that bonus in a full and timely manner. So let's talk about full and timely. Full means I'm looking at my buyers and saying, if you buy this new construction property, the builder is offering me a $500 bonus. I have fully disclosed what I get if they buy. And timely means we share that with them before they present the offer. They need all information when they are deciding what they want to offer. Y'all sitting at the closing table or the settlement table with your buyers and saying, by the by, as soon as you sign, I get $500. That's too late. Full and timely disclosure means we share that with them, the amount. We've got to get consent for additional compensation. A couple restrictions on compensation. I don't have to disclose what the firm is going to collect to a customer. So whatever the firm is going to collect as a part of this transaction, that's only a client level service. And the other restriction, the individual broker doesn't have to tell anybody how much of the firm split you're going to get. So the firm collects X amount and then they share that with you. What they share with you is nobody's business. The only thing we have to disclose to clients is what the firm is going to collect. It's kind of like those of you that are paid hourly. Do you ever have that random relative ask you how much you make an hour? My thought is always, it's just none of your business. Here we can actually say that. None yet. And remember, you guys, the commission doesn't get involved with our commission, referral fees. They don't get agent bonuses. Good rule of thumb, commission doesn't get involved with our commission. If you're not happy with the split from your firm, go find another firm. It's pretty much that simple, pretty much that easy. Remember, you guys are shopping around, so you have commission plans to compare. There's only one time that the commission will get involved with matters of money. I mean, they collect a renewal fee every year. I'll talk about that. But there's only one time that they get involved in agency. Anybody remember what that one time is? The only time they can fine a broker? Give them the chat. Yeah. The only broker they can fine is the timeshare developer. And they can fine the timeshare developer up to $500 per violation. That's the only time they will get involved with commission. Last week, we talked about your unlicensed persons, making sure that you are properly compensating them. Compensation to unlicensees is hourly or salary. They cannot be paid per transaction. They cannot be paid a referral fee, because that takes us back to our funnel. The transfer of real property for others for compensation requires a license. In Unit 21, we introduce you to RESPA, the Real Estate Settlement Procedures Act. And RESPA does various things to protect the consumers. And one thing RESPA does to protect the consumers, they don't allow kickbacks or referral fees for recommending settlement service providers. Settlement service providers are those that offer a service during the settlement process. You and I are settlement service providers. The attorney, the lender, the home inspector, the appraiser, all those people involved in due diligence, helping us get from offer to settlement or contract to settlement. And I can recommend my buyer use a home inspector, but RESPA says the home inspector can't thank me by giving me a $25 gift card or taking me out to lunch. Anything of value. All that home inspector can do is say, thank you for sending me your buyer. RESPA specifically says, give or receive. So if somebody tries to offer you a $25 gift card, no thank you. Not unless you want to face those penalties of RESPA. We talked a little bit about your broker in charge last week, talked about how they became BIC eligible. Once you're BIC eligible, you can become the designated broker in charge. So every office has to have a designated broker in charge. I need a BIC under every roof. So every office location has a designated broker in charge, which means they have one designated BIC that's responsible for the day-to-day activities of that office. The designated broker in charge is responsible for any unlicensed staff. They're responsible for provisional brokers. And even as a full broker, the designated broker in charge does have some responsibilities to make sure that the full broker is acting accordingly. An example of something that the designated BIC is responsible for the full broker, agency. If the full broker is not handling agency properly, then the designated BIC may get popped as well. So I got one BIC and only one BIC under each roof, each office location. Some of you at some point in your career may want to go out on your own, and you may want to start your own firm. And when you're ready to start your own firm, we need to revisit a couple things on license law and commission rule. Go to the commission's website so you make sure you are setting your firm up properly. And as you're setting up your new firm, you do have a couple options. You can create the firm, and if you qualify, you can designate yourself as the broker in charge of your firm. If you don't want to be the BIC, then you hire a BIC of your firm. You bring on somebody else to act as the designated broker in charge. That's one option. Another option, by the way, you'll learn about setting up your firm. That's coming in post-licensing. So there's still more to come on that. Well, everything to come on that. So you don't want to be a BIC, you don't want to have a firm. Your other option would be to act as a sole proprietor, also as a sole practitioner. What does the word sole tell us? How many? Sole? Yeah, just one. You're a one-man show. You're a one-man firm. You can be a sole proprietor and not be a BIC. A sole proprietor and not be a BIC. If you're not going to have a trust account, if it's just going to be you And if you don't advertise your brokerage services, to be a sole proprietor without a BIC, you cannot advertise your services in any way, y'all. You can't give out a business card. So who is a sole proprietor? Well, it's the referring agent. It's the retired agent. It's somebody that has that book of business or that clientele. They don't have to advertise. People know, those that reasonably know that you have a license. Who reasonably knows you have a license? Mom, dad, spouse, previous clients. So for those of you wanting to go on your own, you need to ask yourself, what do you want to do? Do you want to be a referring agent only? In which case you can consider setting yourself up as a sole proprietor. If you want to be out advertising your services, then you need a firm with a designated broker in charge. So you do have some options. You will get much more about this in post licensing. Just introducing you to your choices. And as a nice refresher, to become BIC eligible, you have to have an active license. You can't be a provisional broker status. You have to have some experience under your belt within the last 5 years. So they look at 2 years full-time in sales, 4 years part-time in sales within the last 5 years. And then you have to complete a 12-hour BIC class. These 3 activities make you BIC eligible. Once you're BIC eligible, then what we're saying is you're eligible to become the designated broker in charge. Once you become BIC eligible, maybe you go on to be designated BIC, maybe you don't. But once you become BIC eligible, to keep your eligibility status, you have to renew your license each year, and you got to keep that license on active status. We are very shortly going to talk about the renewal process. We're going to talk about an active status. If for every reason you don't maintain your BIC eligibility status, you go back to being a full broker. And as a full broker, if you want to be BIC again, you got to go back through that 12-hour class. So again, renewing is very important, and that conversation is coming soon. Questions about the BIC or the sole proprietor? Another general brokerage rule. We're good with this, yes? Can I draft? Y'all, there's a reason we keep hitting on this. I've had clients look at me before and say, can't you just add this? Can't you just delete that? And my answer every single time is no, I cannot. Remember, Old Car says we follow our clients' lawful instructions. And no matter what they say, they cannot make me draft. They cannot make me edit their sales contract. I don't know. When people look at me and say, can't you just, my guard goes up because I don't know what's going to follow from that. And in this case, no, I just can't. NC Realtors has provided us with pre-printed forms for us to look at, for allow me to fill in the blanks. Specifically in this class, all we looked at was our listing agreement, our buyer's agency agreement, and our sales contract. Many, many more pre-printed forms to come as you advance in your career. And there's a common misconception out there that as a broker, I can only use pre-printed forms provided by NC Realtors. The truth is, Commission Rule 58A.0112, don't need to know the number, I just have it there for reference. Commission Rule 58A.0112 says I can use any pre-printed sales contract as long as it satisfies the criteria of this commission rule. And one thing specifically that this commission rule says is that these pre-printed forms have to be drafted by an attorney. So even if you're using something that's not NC Realtors, you can, as long as it meets this criteria. It's not uncommon for builders to have their own sales contract, for example. So NC Realtor forms are not the only ones we can use. We mentioned the other day about reporting criminal convictions once you're licensed. We all know you have to have a background check before you get your license. Once you're licensed, if you get yourself in trouble, we've got to report that to the Real Estate Commission within 60 days. Specifically, if you get convicted of a felony or a misdemeanor, we've got to report that within 60 days. Please note the word convicted. You don't have to report when you're charged. You only have to report when the gavel comes down and the judge says guilty. That's when you're convicted. So head bobs, we hear the difference between charged and convicted. This is one place they like to trick you. So once you're convicted of a felony or a misdemeanor, we have to report it to the Real Estate Commission. Also, some of you might have another professional license. Maybe you have your nursing license or your CPA, cosmetology license. Maybe at some point you get your real estate license in another state. Maybe you get your South Carolina real estate license. If you get yourself in trouble with your other licensing board, we have to report it to the North Carolina Real Estate Commission within 60 days. So this is what's up. Maybe they will do something to you, maybe they won't. Maybe if you have multiple convictions, then it may cause them to review your character. If you have multiple disciplinary actions, at some point they might question your character. Are you harming their public? Reporting it itself, reporting the activity, is no guarantee that you're going to get in trouble or not. I don't know. They have to review it on a case-by-case basis. If you're convicted of fraud, that doesn't look good for taking care of their public, does it? For example, this is what I do know. Failure to report it within 60 days itself is a violation of commission. So reporting it may or may not get you in trouble. Failure to report it will. I don't know what kind of house y'all grew up in, but my house, it was better that you come home and tell mama what you did versus letting mama find out on her own. Don't let mama go to church on Sunday and let somebody tell her what you did. Anybody else? Aren't all mamas the same, right? Think of the commission as mama. It's better to tell them. Failure to tell them. Who are you reporting to? You're reporting to your licensing board, which is the North Carolina Real Estate Commission. I've seen this in disciplinary actions. Failure to report a conviction. And they've gotten suspended for a couple months. Yes, we have to report to the North Carolina Real Estate Commission. It's up to us. It's my responsibility to tell mama that I messed up. Questions on this? Specific to North Carolina is our RPODs and our MOG, Residential Property and Owners Association disclosure, and the mineral and oil and gas rights. Remember, you guys, the RPODs and the MOG are seller disclosures, which means who is responsible for completing the form? Me? No, it is the seller. I can't do it for them. Even if they ask, can't you just do this for me? No, it is a seller disclosure. Specifically, the RPODs is a mandatory form, which means the seller has to provide it. But remember, caveat emptor gives the seller the option if they want to disclose. The seller has the option to say, yes, there's a problem with the property. No, there's not. Or I'm going to exercise my rights under caveat emptor and say no representation. It's a mandatory form with optional disclosure that the seller completes. The only thing I do, I'm going to help deliver it. I'm going to help get it from the seller to the buyer. I'm going to help get a copy in the buyer's hands so they can review it. In most cases, prior to even presenting the offer. The delivery method doesn't matter, just as long as we get it to the buyers. And remember too, you guys, only the seller can hide behind caveat emptor. As a licensee, we always have a duty to disclose material facts. I feel like that's worth saying again. We always have a duty to disclose material facts. Did y'all hear my absolute word? Is there an exception to always? We always have a duty, regardless of how the seller completes their disclosures. We can help, we can answer questions. Do not touch that pen. I had a seller once, she had a rental condo that she was ready to sell. And my seller was, I mean, bless her heart, she had to be pushing 80, if not early 80s. And at that time, the RPODs, I'm not making this up, was like font 6. Nobody could see it, specifically those that were pushing 80. And I handed that to her because she didn't do email. So we were at the kitchen table doing everything. And I handed that to her and she said, Julie, I can't read this. I said, do you want to disclose? And she said, I do. I want to be very honest. I appreciated that as a buyer. So I want to give that. I said, it's fine. So you know what I did? Bellied up to the kitchen table and started reading. Welcome back. It's not like I grabbed the pen and said, oh, let me just do it for you. Would that have been the easiest thing for me to do? Probably. Questions on our RPODs or MOG? Subsurface rights, mineral and oil and gas mandatory disclosure. We spent Unit 21 talking about closing disclosures and our responsibility for these closing disclosures. We talked about buyer's debits and credits, so we can help our buyer determine how much they have to bring to closing. Specifically, commission rule says I have a duty to review these things for accuracy, for things that I can verify. Make sure the bottom line figures add up. And when you find an error, we have a duty to report that. Failure to do so would be willful omission. So when you find an error, report that to the attorney and or lender so they can get it corrected. Remember that A in old car is accounting. And that is from day one, the whole way through to settlement to closing, making sure that their final figures on the CD are accurate. Make sure your buyer is paying what they're supposed to pay and your seller is hopefully getting what they are supposed to get. That also says we have a duty to ensure delivery of the CD. So this is the deal. Most of the time at the settlement table, the closing attorney will hand buyers and sellers a copy of their CD. And since I'm at settlement with my clients, I see that go down. I ensure that my people got a copy of that closing disclosure. If you're not there or you don't see that, send them a copy to make sure so you know that they got a copy of that closing disclosure. Any questions? So let's go ahead and take our first break. When we come back, the long, much anticipated trust account. Welcome back. Cameras are back on. I am taking attendance. And we have spent our time together dancing all around the trust account. But now here in the comments, we're going to hit it full on. So let's talk about the trust account. Please make a note. The trust account can also be referred to as the escrow account. The one or two are the same. And all a trust account is an account that has somebody else's money. That's it. Your money does not belong in the trust account. Somebody else's money doesn't belong in your operating account. Operating account is for you to receive commissions and pay bills. Trust account is to hold somebody else's money. Why don't you guys set your chats to private if they're not already? And tell me in a private chat, abbreviate as you like. I know what you speak of. Tell me in a private chat, what are some examples of monies that we would hold for others in a for sale transaction or in a for lease transaction? What are some examples of monies that we may hold in a trust account? May you be in sales or property management. So I'm getting lots of good stuff. Most of it I'll agree with. Some things I'm getting. There it is. Awesome. One big thing I'm getting, and I absolutely agree with, is the earnest money deposit. The earnest money goes in a trust account. It's held by an escrow agent. An escrow agent is that one that has an escrow account. The escrow agent may be the sales firm. It might be the real estate firm. The escrow agent might also be the closing attorney. Closing attorneys must have a trust account so they can pay the proceeds of the sale after the transaction. It's not their money that they're paying the proceeds. It's the buyers and the sellers. So they have to have a trust account. Another great example I'm seeing is tenant security deposits. If you're in property management, tenant security deposits will go into an escrow account. It's just there for safekeeping. Rent might run through a trust account because the property manager is collecting it on behalf of the owner. So they collect the rent, pay the bills, pay themselves, and then whatever's left, they can pay the owner. So property managers often run rent. Somebody said HOA dues, possibly. If you have special assessments, that's a great one. What I saw in here that I don't agree with, the due diligence fee does not get held in a trust account because the due diligence fee is paid directly from the buyer to the seller. The buyer pays the seller directly, makes a check out to Mr. and Mrs. Seller. Those are the only two parties that touch it. Most property management firms, I cannot think of an exception, so I'm just going to say most, have to have a trust account because they are holding security deposit, because they are collecting rent. A lot of sales firms have done away with the trust account because we figured out that the closing attorney can handle it, put the liability on them. Nobody needs a trust account if they're never going to hold money for somebody else. So as long as your firm's policy is that we will not hold other people's money, then your firm may not have a trust account. The individual broker probably will not have a trust account unless you are a landlord renting for yourself. Then once you're licensed, you will need a trust account to hang on to that security deposit. So again, the big picture, a trust account is an account that has somebody else's money. Firms that have a trust account also have an operating account. Your money belongs in the operating account. So with the trust account, there's three primary features, three things that sets it apart. It's separate, meaning it's separate from your operating account. You got two sets of checks and checkbooks, bank statements. They are two totally separate accounts. The custodial piece, those that have access to the trust account don't have money in there. So your broker in charge is going to have access to it. Their staff can access it. You can have an unlicensed employee managing the trust account on behalf of the BIC. But the BIC doesn't have money in there. The unlicensed employee doesn't have money. It's custodial, meaning those that have access to it don't have money in there. And then the money in the trust account is available on demand. I'm not spending it, I'm just holding it. Let's say we're in a sales firm and it's a really, really bad day. And every single one of our contracts terminate today. That's a bad day. I have got to be available to write those checks from the trust account to the appropriate party today. I can't say, well, wait till Friday when I get paid. That money is there. I haven't touched it. I can't spend it, and it is available on demand. The owner of the trust account does have the right to make sure that the funds have cleared, but they can't hold it until I get paid on Friday, for example. Thank you. Somebody said they are trusting you with their money. And that's how we learned it in the legal world. Thank you for sharing that. They are trusting you with their money. So it's separate, it's custodial, it's available on demand. Thank you. Demand deposit account. The bank that it's in has to be an FDIC. You guys ever walk in the bank and you see the sticker on the front door, FDIC? That's telling you a lot of credit unions are not FDIC. So before you open your trust account, if you are, make sure it's FDIC. The bank has to lawfully be doing business in North Carolina. They don't have to be physically located in North Carolina, but they have to lawfully be doing business in North Carolina. And then the escrow agent and the bank have to agree to make the records available if the North Carolina Commission wants to review. They have been known to send spot checkers. If they're sending them to Greensboro to investigate a matter, there's nothing that's stopping them going, look, there's a real estate firm. Let's drive in and check out their trust account. And when they walk in the door, it's got to be ready for them to review. If the firm causes a flag to go up, concern, expect the commission to show up to review your trust account. The words themselves, trust account or escrow account, have to be on everything. Signature cards, bank statements, deposit tickets, checks, whatever we get regarding this trust account has to clearly state that it is a trust account. The reason for this is in the event that the broker in charge is a one-man show, they don't have anybody with them, and that broker in charge passes away. We don't want the monies in the trust account to get locked up in their estate. So the words themselves have to be clear what this account is for. And then we need accurate records to identify each owner or each who has the funds. So may that be owner, buyer, seller, or for rent situation, lessor or lessee, if you're in property management. It's got to clearly state who are the parties, the transaction, the amount. Firms only need, escrow agents only need one trust account. There are firms out there that do for sale and for lease. Now they could choose to have multiple trust accounts, one for the sale and one for the lease. But commission rule says they only need one. You can have earnest money and security deposit in the same account. The exception to this rule, if you're a property manager managing HOAs, each HOA needs their own account. So your property manager, you're managing HOAs. If you have 5 HOAs, then you have 5 trust accounts. Hands down, without a doubt, the biggest violation of the trust account, what you're going to see in the disciplinary action over and over and over again, is commingling. Commingling is when you have your money in the trust account or somebody else's money in the operating account. Keep those separate. There have been cases, y'all, and hey, it starts off innocent. The city is going to cut your power off if you don't pay the power bill today. You have no money, but you know you're getting paid on Friday. So can't I just borrow money? There I go. Can't you just borrow money from the trust account to pay your power bill, and you'll pay it back as soon as you get paid on Friday? Is that okay? No, that is commingling. Remember, the trust account is money on demand. The exception to this rule, if the bank of the trust account charges monthly fees and they're going to deduct it from the account, the escrow agent can have no more than $100 of their own money to cover those monthly fees. And when that depletes, you can replenish it, never more than $100 of your money in the account, only for the purposes of paying those monthly fees, if applicable. Some trust accounts might be interest-bearing accounts. That would have to be specified in the sales contract or the lease. Our sales contract 2T says that the escrow agent may have your money in an interest-bearing trust account. If you're an escrow agent, once a month your interest comes out. You're collecting interest on somebody else's money. And once you get paid that interest, you got to transfer it from your trust account to your operating account. That's your money. So interest-bearing accounts are allowed as long as the parties are notified in the sales contract or the lease. The broker in charge is ultimately responsible for the trust account. They may have and very likely have employees managing it, maybe an unlicensed employee managing it. But if the North Carolina Real Estate Commission walks in the door and says, show me your books, they're talking to the BIC. The BIC is the one that will suffer any disciplinary action as a result of mishandling the trust account. And then records have to be current and accurate. I think a good rule of thumb here, the bank statement comes out once a month. So when that bank statement comes out, make sure things balance out. Make sure your amounts are correct. Remember, needs to be available at any time if the real estate commission wants to review it. So because of that, we're going to keep it current and accurate, make sure that it balances out to the bank statement. Specific to earnest money deposit. Earnest money is paid by the buyer at the time of contract formation, and that earnest money goes to the escrow account. If the if the closing attorney, if the settlement agent has the trust account, then the earnest money is already there and the attorney can do what they need to do for settlement. If the real estate firm is holding the trust account, the real estate firm has the trust account, they have the earnest money. Commission rule says that that earnest money cannot be dispersed from the real estate firm no more than 10 days prior to settlement. If you affiliate with a firm that has a trust account, they will tell you their policies. They will let you know when to request a check so you can take that to the attorney for settlement. They will tell you their guidelines. Commission rule just says no more than 10 days prior to settlement. If we don't make it to settlement and the parties terminate, again, quick refresher, if we terminate within due diligence, if the buyer terminates within due diligence for any reason, they'll get their earnest money back. If the buyer terminates after due diligence for any reason, now they are in breach and the seller will get the earnest money. It's Unit 10. Here's the deal, you guys. If the parties terminate, the contract's pretty clear about what happens to the earnest money deposit. The contract spells it out. But here's the deal. The parties, in the event of termination, have to agree to release the earnest money. So if we terminate, that earnest money isn't released automatically on its own. The parties have to agree to release it. And if either party is not agreeing to release it, then we have disputed funds. The escrow agent is an impartial third party. They're just a holder. They can't make decisions, even though an attorney can interpret the contract. They can't make decisions about what happens to that earnest money deposit. So we terminate, the parties have to agree to release it, and there are forms for that. NC Realtors has us covered, termination forms. If either party, and honestly, the one that's not signing it is the one that's not set to get the earnest money deposit. So somebody's upset that the other party's supposed to get it, and they're not going to sign. So now we have disputed funds. The escrow agent needs to make a couple attempts to try to resolve, maybe send certified mail, a couple emails. They need to make a couple attempts to try to resolve it. Bottom line, if it's still in dispute, at some point, the escrow agent has the right to turn that disputed earnest money over to the clerk of courts and let the two go downtown and hash it out. And now we're dealing with attorney's fees. By the way, the first thing the mediator is going to want to see is the contract. And they're going to look at the contract and says, well, it says right here, this is what happens to the earnest money. So it'll be a quick, but somebody's going to have to pay. The losing party will generally have to pay both sets of attorney's fees. So brokers, let me say this. Nobody likes to terminate. Fair statement. Nobody likes to terminate. And your party may be digging their heels in. No, I'm not signing that. All right. Give them a minute or two to settle down. Things generally look better in the morning than they do the night before, right? So let them sleep on it. And the next day or two, if they're still not willing to release it, I'd actually sit down and read the contract to them that they signed. We can try to help to get these funds resolved so everybody can move on with their lives. But after a certain amount of time, the trust account, the escrow agent says, I'm done. I'm going to release this to the clerk of courts. Good luck to you guys. I've recently learned that if they never go to the clerk of courts after X amount of time, it just gets turned over to the state. That's more money to the state. I'd rather the other party get it than the state get it, right? So help them understand. Nobody likes to terminate, but it is what it is. Questions on that? Disputed funds. Also about the trust account in general, all funds, earnest money, security deposit, etc. Monies have to be deposited within 3 banking days of receipt or contract formation, whichever one happens first. Most of the time, escrow agents are dealing with receipt. So we go under contract, buyer writes a check, buyer's agent delivers check to escrow agent. Escrow agent now has 3 banking days of receipt to deposit that trust account. On the sales side, you may run into a situation where the buyer says, while we're still negotiating, the buyer says, hang on to this earnest money check for me. Maybe they're from out of town and they're getting ready to get back on a plane after you showed them properties all week. And you're going to present an offer for them as they're boarding the plane. They might leave you with a couple checks. Nobody owes money until we have a contract. So they hand you the check, we negotiate it, we have acceptance and communication of acceptance. Congratulations, folks, we're under contract. Now the escrow agent has 3 days of contract formation. Your firm may have a policy on that. The exception to this rule makes me nervous. Cash. If your firm allows you to collect cash, y'all, I've seen 5-digit earnest money deposits. If your firm allows you to collect cash, that needs to go in the bank immediately because that's readily available funds. Even if this contract never, if the offer never turns into a contract, then we can still write a check out like later today. Again, your firm more than likely has a requirement or a rule that restricts you from walking around with $10,000 in cash. Does that make you nervous? That makes me nervous. I like the firms that say no cash. We can always get a cashier's check, money order. Talking about walking around with somebody else's money. Again, buyer hands you a check. We're in the throes of negotiation. Buyer hands you a check as they're getting ready to get on the plane. You guys, my PBs, cannot walk around with somebody else's money. So if they hand you cash, if they hand you a check, you need to immediately get that to your BIC. They will hang on to it while you're negotiating. Provisional brokers cannot walk around with somebody else's money. Full brokers Should not. Do we hear the difference in could not, cannot, and should not? Because here's the deal, you guys, bottom line. When you have somebody else's money in your possession, it is your responsibility. So my suggestion is to deliver it, get it to where it needs to go. Any of us, provisional broker, full broker, or BIC, may be handed option money or due diligence fee. These are monies paid directly from the buyer to the seller. If we are handed option fee or due diligence fee, again, that no more than 3 days makes me a little nervous. I say get it to where it needs to go, get it out of your possession. But if we are dealing with option money or due diligence, we are only acting as delivery people. My sole purpose of having this money is to get it from point A to point B. And please don't take 3 days to do it. Get it to where it needs to go. So you're a buyer's agent and you successfully negotiate this contract. Buyer accepts, we have communication of acceptance. Good job. We're under contract. So you tell your buyer, all right, I'm going to meet up with you guys this afternoon so I can get your checks. I need an earnest money check made out to the escrow agent. I need a due diligence check made out to the seller. So you meet your buyers to get those checks and you are en route to deliver them. And the buyer calls you and says, don't deliver those checks. I've got to follow their instructions. It's not my money. I don't get to say what happens to it. So your buyer calls you and says, whatever you do, do not deliver those checks. Well, buyer, understand, if we don't deliver them on time, it could give the seller a reason to terminate per the contract. I don't care. Don't deliver it. Yes, sir. Yes, ma'am. It's their money. We've got to follow their instructions on what to do. But guess what? If it's out of your hand, it's too late. It's already been delivered. Is everybody good with that? Do I have questions on that? And remember to you guys, nobody owes anything until we have contract formation. So if you're holding that buyer's earnest money while we're negotiating, if that offer never becomes a contract, then we dispose of that check per your buyer's instructions. They want me to write void on it. They want me to shred it. They want me to mail it back to them. If the offer never becomes a contract, I dispose of that check per their instructions. And then bottom line, all of us, for sale and for lease, anytime you have somebody else's money in your possession, you're responsible for it. If your firm doesn't have a trust account, you're still going to be playing delivery person. I'm telling you, just get it to where it needs to go. Questions on the trust account? The last little piece of the comments then goes over our BPOs and CMAs, broker price opinion and comparative market analysis that we talked about back in Unit 17. We said the attorney does, or I'm sorry, the appraiser, the appraiser does the sales comparison approach to determine value. You and I do BPOs and CMAs to determine probable sales price or probable lease price. Full brokers can do a CMA or BPO for a fee for an uninterested third party. You're not getting business. Somebody just wants your opinion on what this property is worth. Maybe it's a relocation company located in another part of the state, for example. They may pay you for your opinion, pay you for a CMA. As a PB, you can do it. You just can't do it for a fee. None of us can charge a fee when it's just part of doing my job, general brokerage duties. So when my seller asks me what I think they can sell their home for, I'm doing a CMA, that's just part of my job. My buyer says, this is my dream home, I want to make an offer. The next thing out of their mouth is going to be, how much should I offer? Now I'm going to do a CMA and I'm not going to charge them for it. BPOs and CMAs are one of those rarer things that are covered under license law and commission rule. I'd say most is covered under one or the other, but BPOs and CMAs, they're covered under both. There's training out there. You'll have their bit to make sure we're properly performing these things. I just got an email last week from the Winston-Salem Board of Realtors. They're doing another CMA class. So once you guys sign up, pay attention to these emails. These are great opportunities for you to get this additional training. And that gets us through the comments. Again, I like this section, one, because it's a nice review. A lot of what we've seen somewhere or another. So the rest of what I have in this section is license law or commission rule, but it's not covered in the comments. I never asked you guys to read license law. I never asked you guys to read commission rule. I just asked you to read the comments because that's where the majority of your state specific section comes from. So the rest of what I'm talking about is license law or commission rule. I don't have page numbers, but there are some points that we need to go back and pick up. One thing addressed is our proof of licensure. Once you get your license, they'll mail you a nice 8.5 by 11. You guys go get a frame for this. You worked hard for this piece of paper. I have this frame and I have my marriage license frame, but dang it, I got this thing framed, right? So go get you a frame. In addition to your nice 8.5 by 11 license, every year that you renew, you get a pocket card. And the pocket card is just that. This thing cuts out and it fits very nicely in your wallet. They also have a digital pocket card, so you can have it on your phone. If you're a nerd like me, you got both. And whenever we're practicing any brokerage activities, we have to have our pocket cards on us. These things renew every year. Again, we're getting ready to talk about the renewal process. So any brokerage activity, we're required to have our pocket cards on us. Obviously, buyers, sellers, landlords, and tenants. If you go to take a CE class, that's a brokerage activity that requires your pocket card. If you're going to go on vacation, you're going to go out of town, you start talking to people, there's a good chance real estate's going to come up. People love to talk about real estate. So, ladies, when you're packing your vacation purse, go ahead and grab your pocket card because you never know when the conversation is going to come up. Again, it renews every year. Talking about the renewal process in just 1 second. The firm also gets an 8.5 by 11 license. The firm has to display their license in the office. The firm has to have their license displayed. Another thing covered off the comments, but in the syllabus, disclosure of offers prohibited. We cannot disclose the terms of the offer without the offeror's permission. Who is the offeror? You hear my play in words? It's the giver of the offer. Maybe it's the buyer making the offer to the seller. Maybe it's the seller countering, and those roles reverse. Whomever is giving the offer, we cannot disclose the terms of the offer without the offeror's consent. This came up a lot in that crazy multiple offer world we're slowly coming out of. Listing agents, you were getting multiple offers. It was almost a guarantee you were going to get multiple offers. Listing agents were getting calls from buyer's agents, and buyer's agents were asking, what's the highest price offer you have in your hand right now? There's no commission rule that stops them from asking. The commission rule addresses how we respond. Don't get caught off guard, you guys. If you're going to answer that question of what's the highest price offer you have in your hand right now, you can only answer that with express authority of that offeror. A more appropriate answer is advise your buyer to bring their best and final offer, and we will consider all offers at the same time. Did I share anything? A lot of agents got, and we were caught off guard. So that takes us back to the whole thing before you respond, stop and count to 5 or 8, depending on how you're, what do they call that, verbal vomit, where you don't have a filter between brain and mouth. It just it falls out. Stop and think, count to 5 before you say, advise your buyers to present their best and final offer, and we'll consider everything. Another scenario where this might come up. You're a buyer's agent and you're working with 2 buyers and they both become interested in the same property. Remember, I'm a fact finder. I'm not telling anybody what to do. I'm providing the facts for them to make an informed decision. And I'm certainly not going to pit my buyers against each other. This is what the Joneses are offering. This is what the Smiths are offering. We cannot disclose those terms. What I'm going to do is I'm going to pull the same CMA for the Smiths and the Joneses, and I'm going to let them decide what they want to offer, treating them both equally and fairly and letting them decide. Questions on this? Renewal. We've got to renew our license every year. So you get your license. Congratulations. Send me a text because that's why I do what I do. I get the text from you guys that says, today I passed my state exam and I'm officially a real estate broker. And I will shed a tear with you because I understand where you are. I know where you're at. So once you have your license, we have to renew it every single year. The Real Estate Commission does not operate on a calendar year. They operate on a physical year. And the Real Estate Commission's physical year is July 1st to June 30th. Every single one of our licenses, individuals and firms, our license expires at 11:59 p.m. on June 30th unless we renew. To renew your license every year during the renewal period is May 15th to June 30th. During the renewal period, we have to pay the renewal fee. So the first step in renewing your license is to pay the renewal fee between May 15th and June 30th. Paying the renewal fee makes your license current. When you guys see the word current, let's do a little play on words. When you see the word current, what I actually want you to see is currency. Currency meaning we have paid the fee. So a current license means that the money has been paid. The renewal fee has been paid. Last year and the past, I can't remember how many years, the renewal fee has been $45. There is talk of them increasing that for this year to $50. You're not going to be tested on how much the renewal fee is. I just know I get asked that a lot. So 45, possibly going up to 50. Paying that fee, whatever it is, that current year, paying that fee makes our license current. Failure to pay the fee means at the stroke of midnight on July 1st, your license is expired. So the first step in determining our licensing status is about the money, not about the education. A current license has nothing to do with education. It's all about showing them the money. Pay the fee, your license is current. Failure to pay the fee means your license is expired. A current license may have one of two statuses. Once you pay the fee, the next question is, where are you on your education? If your current license is active, it means that you are up to date on your education. I'm going to talk about CE in just a second. So your license is current, meaning you paid the fee, you show them the money. And now the next question is, where are they on their education? So you're active when your CE is complete. Provisional brokers, you will be active when you affiliate with a firm. Once you're a full broker, all you have to do is pay the fee and do CE every year. It rhymes and everything. Fee and CE once you're a full broker. Again, more on CE in just a second. The other option for a current license is an inactive license. You're current because you've shown them the money, because you have paid them the fee. But you are inactive because you're a PB that's not affiliated. You didn't do your CE or your post licensing on time or by choice. You may choose to put your license on inactive status. You may choose to never activate your license once you get it. There's several reasons why people put their license on inactive status. I mean, life happens, right? What if you're ready to start a family? What if you need time to care for ailing parents? Life happens. It is recommended that you maintain an inactive license. In other words, at a minimum, pay the fee. And I will tell you why in just a second. Why I recommend that, not the commission, but Julie recommends you pay the fee. You could ride for the rest of your life on an inactive license. All you have to do every year is show them the money. If you want to reinstate an inactive license, your license is inactive for whatever reason, and now you're ready to activate it. How it's activated is dependent on any CE deficiency. So if you're inactive, but you are current, you are up to date, you are inactive, but you are up to date on your CE, you decide you want to activate, all you have to do is submit a license activation form. And poof, you're active. Some of you may choose to take post licensing while you're still inactive. Once you complete the post to activate yourself, you just submit your license activation form. If you're already active, you finish post licensing, you're already active. You don't need to do anything. So inactive without a CE deficiency, just submit the form. If you've been inactive for less than 2 years and you have a CE deficiency, they're going to make you get caught up on your CE. So they're going to make you do this year's update and elective. Again, we're talking about CE in just a second. They'll make you do this year's update and elective. And depending on your deficiency, they may make you go back and do an extra elective or two. I can't answer what they're going to make you do. It's a case by case. So if you're inactive with a CE deficiency and you're ready to be active again, just call the real estate commission and say, what do I need to do? And they will let you know specific to your record, specific to your account. So inactive for less than 2 years with a CE deficiency, they're going to make you get caught up on CE. If you've been inactive for more than 2 years and you have a CE deficiency, they're going to make you do this year's update and elective. They're also going to make you go back and take 2 out of 3 post licensing classes. 2 years without CE, y'all, a lot has changed. 2 years without education, without update, a lot has changed. So they make you go back. The good news is you can pick which 2, pick your favorite 2 post licensing classes, and you can go back and take those again. They'll activate you, but you got to knock those out within 6 months. Again, you can ride for the rest of your life on an inactive license. You can take CE on an inactive license. So if you think you're ever going to activate, I'm going to go back for a second. If you think you ever want to reactivate, at a minimum, why not take CE every other year? Keep you out of post licensing again, right? You can take CE every year, but at a minimum, do it every year. Current is nothing but active. No, a current license can be active. A current license can be inactive. What does a current license mean? You have paid the renewal fee, and that's all a current versus expired license tells us. Either you paid the fee or you haven't. If you're expired, I don't care. You could have taken all of the CE classes, but the fact that you didn't pay the fee means that your license is expired. A current license has everything to do with money. It has nothing to do with education. Questions on reinstating an active license? Let's take 10. When we come back, we're going to talk about that expired license. What happens if you fail to pay the fee? Welcome back. I'm taking attendance. Current license means you paid the fee. An expired license means you have not. The renewal period is May 15th to June 30th, and trust me, they'll let you know. They're almost a little bit obnoxious about it. They send emails out. They have stopped snail mailing postcards. But your BIC will remind you. If you don't know it's time to renew, it's because you're not paying attention to anything going on around you. So check your emails every once in a while because you get important information like, hey, time to renew your license. Renewal period is May 15th to June 30th. A renewal period means that's when we pay the renewal fee. Failure to pay the renewal fee during the renewal period means at the stroke of midnight on July 1st, your license is expired and all brokerage activity must stop immediately. Can you practice on an expired license? No. So what happens if you allow your license to expire? Maybe it was by choice. Time to start a family. I'm going to let my license expire. Maybe it's because you forgot. What happens if you allow your license to expire for any reason? If you're expired for less than 6 months, you pay the renewal fee and you pay a reinstatement fee. Same amount. So you wake up on July 1st and go, are you kidding me? I forgot to pay the fee. Oh, for crying out loud. All you got to do is send in the amount and poof, you're active again. Less than 6 months, pay the fees, submit an activation form. More on those forms in post. If your license is expired from 6 months to 2 years, you have to pay the fees, renewal fee and reinstatement fee, and then you have a choice. You've missed some education in that 6 months to 2 years. So you have a choice. You can either go pick your favorite post licensing class and retake it, whichever one you like the most, or you can go back to Pearson VUE Testing Center and sit for your state exam again. I believe most of us would choose option number 1. Y'all have been to Pearson VUE once. You don't need to go back. Just knock it out and post. So you're expired 6 months to 2 years. You got to pay the fees. You got to prove you still have the knowledge, have the material. Is everybody sitting down? Maybe brace yourself a little bit. If your license is expired for more than 2 years and you want to reinstate, you have to start all over. I will see you at my next pre-licensing class. If you've been expired for more than 2 years, they're going to treat it as if you never had a license. So remember earlier when I said I recommend paying the inactive fee and riding for the rest of your life on an inactive license? Why? Ta-da. I want to see you guys in post licensing. I want to do a transaction with you one day. As much as I enjoy y'all, don't come back to pre. Y'all been through this once. Don't do it again. Fair enough. So again, you may think I'm done with real estate. I moved on to careers and I'm done. But guys, seriously, $45 a year will keep you out of pre-licensing again. At a minimum, I suggest paying the fee, riding for the rest of your life on inactive. The in-person class I taught before COVID, before the pandemic hit, I had two that were in there because their license had been expired. more than 2 years. And both of them were like, dumbest decision I ever made in my entire life. I keep track of both of them, and I'm happy to say they're both still active. They learned that lesson once. Questions on reinstating an expired license. Expired meaning you did not pay the fee. Questions on any of the renewal process, license statuses. Let's talk a little bit more about soon to be you guys. You guys are close. My PDs, my brokers with training wheels is what I call you. Y'all can ride your bike as a provisional broker, but you can't do it without your training wheels. Your training wheels is your broker in charge. It's your affiliated firm. So as a provisional broker, once you're affiliated, you can do just about everything that a full broker can do, as long as you're under the direct supervision of a broker in charge. There's only a handful of things that we have discussed throughout this class that PBs cannot do, even if you're affiliated. Earlier today, we said provisional brokers cannot walk around with somebody else's money. Anytime you're handed earnest money, due diligence, security deposit, rent, you need to immediately get that to your broker in charge. PBs cannot walk around with somebody else's money. Earlier today, we said the provisional broker cannot be designated opposite of their broker in charge, cannot be designated opposite of your BIC. And then actually earlier today, we also said that a provisional broker cannot charge a fee to do a CMA for a third party. As a PB, you can do a CMA for a third party, that relocation company, but you can't charge a fee. So walking around with somebody else's money, charging a fee to do a CMA, or being designated opposite of your BIC. As an active provisional broker, those are your only 3 restrictions. Not bad, right? You guys pretty much have full authority. You're out there acting as a full broker. You are just still on provisional status because you have more education to get. You've got to get those 90 hours. We're going to talk about those 90 hours in just a second. If your application fee bounces, if your renewal fee bounces, if those funds are not received, that could be cause for disciplinary action. Ain't that something? Make sure you have the money in the account before you start paying for application fees and renewal fees. Let me go back, or redo, I should say, our renewal timeline. Remember, the Real Estate Commission operates on a physical year. So when we talk about the commission's year, it's July 1st to June 30th. And then we have that renewal period for every year, every single year, from May 15th to June 30th. May 15th to June 30th is when they're collecting the renewal fee. I used to be able to say 45 days for $45, but I guess I still can until they announce officially that they're going to increase that to 50. And then I need a new catchy little saying. But for right now, we can still say you have 45 days to pay $45 until we're told otherwise. If it's proposed to go to 50, we'll probably go to 50. So you paid your renewal fee during the renewal period and you made your license current. Full brokers, you have one more step. As a full broker, to make your current license active, you have to do CE. And the deadline for CE every year is during the renewal period, specifically on June 10th. June 10th is when we have to have CE complete. You can take CE. They usually roll it out in July or August. Schools will start offering it in July or August. You don't have to wait until the renewal period. You don't have to wait until June 9th to take your CE. As a matter of fact, they prefer us to take it at the beginning of the year so we can practice with the current information. So we make sure what we're delivering to our buyers and sellers is what currently is going on in our CE classes. So the sooner you can take CE, once they start the new year, the sooner you can take CE, the better. The deadline every single year is June 10th. June 10th, June 10th, June 10th. Put that date up there with importance of like your birthday. June 10th. In order to satisfy the CE criteria every year, there you go, by yours, right? In order to satisfy the CE criteria every year, all we have to do is 8 hours of CE. And they break it down into 2 4-hour classes. There's the update course. It's the same information going to all licensees across the state. They have a general update, also known as a Gen Up. That's for PBs and full brokers. They have a broker in charge update, also known as the BIC Up. That's for BIC eligible and designated broker in charge. Make sure you're taking your appropriate update. Because if you're a PB and you take the BIC Up, you're not going to get update credit for it. So make sure you take your appropriate update. In addition to our update class, we also have to take a 4-hour elective. That 4-hour elective is a topic of your choosing. Schools across the state offer different topics. I have always chosen a topic that can help my career. 2 birds, 1 stone, right? Not only can I get something to help me grow, but I can also satisfy the elective criteria. June 10th, June 10th, June 10th. And y'all, please don't wait until June 10th to do your CE, because there are very rare are there extensions. They may offer an extension for a hardship, but you're going to have to prove a hardship. A hardship is not, I got busy and I forgot. A hardship would be like active military deployment, for example. The pandemic was considered a hardship. There have been, I mean, I could go on, I could spend the rest of the day and all day tomorrow talking about times where people thought they were going to take CE on June 10th. If you're going to do your CE on June 10th on Zoom, what if you wake up that morning and your internet's out? Somebody hit a power pole down the street from you and you don't have power, you don't have internet. What if you're doing CE in person on June 10th and you wake up that morning with a flat tire? Food poisoning. I'm not going to say I've heard it all. I will never say that, but I've heard a lot. And bottom line, failure to do it by June 10th because you had a flat tire, the commission's going to say, you've had all year to do your CE. Why are you waiting until June 10th? There's a very common misconception out there that you can only take CE during the renewal period. Don't buy into that. You can do CE as soon as it's out, as soon as it's available. Questions on your CE? Y'all ready for some good news? You guys don't have to do CE until your second renewal period. Pay the fee. Head bobs, everybody just heard me. Pay the fee. When in doubt, send them money. They'll figure it out. Always pay the fee. But your first renewal period, you don't have to do CE. You can, but you don't have to. So what is this, November? Let's say you guys get licensed in December. Let's say you get your license right before Christmas. The day you get your license starts your clock, starts your time. You'll have to pay the fee next year, 2025, but you won't have to take CE. So whenever you get your license, draw your timeline, and the first time you hit May 15th, pay the fee, no CE. Is that good news? The thinking is you guys, you're just out of pre, you're probably in post, you have the current information. So they give you a year off in CE. Just 1 year off, though. Questions on that? Comments? So here's your calendar for you. June 10th is a CE deadline every single year. June 30th is our deadline to pay the renewal fee. There's a lot going on down at the commission at June. I think the last bulletin I saw, there was about over 100,000 licensees in the state of North Carolina. And we're all renewing at the same time. The commission is processing all of our CE. I think last I heard there's about 60 some people that work at the commission. I hope they bring temp help in during that time. But they have to stop CE at some time, so they have time to process everybody before the new year starts on July 1st. June 11th to June 30th is a blackout period for CE, meaning schools can offer a class, but you're not going to get CE credit for it. So June 10th, June 10th, June 10th to do CE, June 30th to pay the fee. Questions? We've talked about post-licensing. So once you're licensed, you have more education. Once you're licensed, you're on provisional status. What drops your provisional status is completion of our 3 30-hour post-licensing classes. The topics are brokerage relationships and responsibilities, which is an awfully fancy way of saying agency, contracts and closing, and license law and rule, North Carolina license law and commission rule. So you have 3 30-hour post-licensing classes. There is an exam for each post-licensing class that you have to pass to get credit. But everybody take a big deep breath with me. Post-licensing isn't near as intense as pre. You're doing the hard part right now. You guys have 18 months to complete your 90 hours of post-licensing. That 18-month clock starts on the date that's on your license. Whatever date they issue your license, that starts your 18-month clock. Again, don't let that time get away from you. Some of you, once you get your license, you may want to remain inactive until you knock post out. Others of you may want to activate and start practicing and take post on an active license. There's no wrong way to do that. Whatever works out best for your schedule, your finances, your time. No matter who you are, what category you're in, don't let that 18 months get away from you. Failure to complete post licensing within 18 months means you will be inactive, assuming you've paid the fee. It means you will be inactive until you get it done. Even if you were active and you were in the throes of a transaction, your 18-month deadline hits, you were inactive. Can you practice on an inactive license? No, you cannot. Active only. My suggestion, do post licensing as soon as you can while this stuff is still fresh. If you're waiting until 12, 13 months, you're almost going to have to work twice as hard because you've forgotten the basics of agency and contracts, closings. So no matter what route you're going to go, I recommend just knocking it out, being done with it, putting it behind you. Again, that 18 months is a pretty hard line. They may grant an extension for a hardship, active military deployment. But for the most part, we all get 18 months. Questions at all on post licensing? Y'all still got your chat set to private? So tell me in a private chat, A, B, C, or D. Got 30 more seconds, then we'll talk about it. So licensee on active status takes one CE class by June 10th, pays the renewal fee by June 30th. Which of the following is true? So let's break this down. They paid the renewal fee on time. I can see your mouse move. They paid the renewal fee on time. So is their license current or expired? It is current because you paid the fee. The next step is your education, any education deficiency. This licensee took one CE. How many CEs are required? 2. So did they do enough? No. They paid the fee and took one CE, which means their license is inactive, and that inactive license will be effective on July 1st, when that new year starts. So the CE deadline is June 10th, but you're not going to go inactive until July 1st. Pay the fee. Like I said, y'all, when in doubt, just send them money. They'll figure it out. So in other words, you have from June 11th to the end of June 30th to get your affairs together and hopefully get this thing closed. Because on July 1st, your license is inactive. It's current because you paid the fee, but it's inactive because you have an education deficiency. They do send postcards for that. You missed the CE deadline. Note that effective July 1st, your license will be inactive. They give you the warning, they give you the heads up. You will remain inactive until you can take the next year's CE. Most schools start up July, August, something like that. So the sooner you can get CE after July 1st, the sooner you can put that behind you. Any questions on this? The last little piece in this section then is a quick refresher on timeshares. We don't remember much else about timeshares, but what's the one thing we remember? Yep. And don't forget the jazz hands. 5, 5, 5, 10, jazz hands. What's all that mean? Basic definition of a timeshare is the right to occupy a unit at least, please note those words, at least. 5 is the minimum. At least 5 or more separate time periods over at least 5 years. The buyer has 5 days to rescind their contract. The timeshare developer has to keep the deposit in their escrow account for 10 days. In the event that the buyer rescinds, they have that money available to give the buyer their deposit back. On day 11, the developer can move that money from the trust account to their operating account. And then this is the only time timeshare developers are the only time that the Real Estate Commission will fine a licensee. Questions? Y'all turn with me in your book, please, to page 595. $595 is Appendix A. Appendix A is license law and commission rule. It also includes the comments. Appendix A in your book is out of date. I can't tell you exactly what's out of date, but anytime you guys are, never look at a form in your book. Always go to the online learning system. So we will always have the current comments, the current license law and commission rule in the online learning system, not necessarily in your book. With that being said, at the end of Appendix A, on page 729, you have a key point review. There may be a few things that are out of date, so always reference the current. There's also a pretty good student quiz. So here's some additional practice on that state-specific stuff. All at the end of Appendix A. So don't look at Appendix A, but I do think the key point review and the quiz can be utilized for extra practice. Any questions? Y'all want a Kahoot? Our last Kahoot, not just any Kahoot, but our last Kahoot. This is our license law and commission rule Kahoot. The comments, well, license law and commission rule. Yeah, comments plus that other stuff that we covered. So there's your QR code. If you go on the website or the app, you need a game pen. Is everybody in that wants to play on your phone? If you're not playing on your phone, just play in your mind. Let's see how we do. Everybody in? I'm waiting on anybody? All right, let's Kahoot. License law and commission rule, LL and CR. Question number 1. North Carolina Real Estate Commission may take disciplinary action against a licensee who ten seconds. Good job, guys. If you violate license law, they can take disciplinary action. If you violate commission rule, they can take disciplinary action. If you've been disciplined from your other licensing board, note the word may. I'm not telling you they are, I'm not telling you they're not. I'm saying that they may. So any disciplinary action from another licensing board, CPA, nurse's license, even if you have a South Carolina real estate license, that's another licensing board, and they can take disciplinary action. So both. Questions on this one? Who got it right the fastest? Oh. So I got Mel on top, followed by Shay and Cece, Jen and Ashley. Didn't get in time. Watch the recording. I can't send you this Kahoot, but you do have the recording that you could go back and review. And you might still be able to join. Well, the QR code's gone. But yeah, you go back through the recording. Question number 2, a real estate license must be renewed no later than every 10 seconds. June 30th. Renew means what? Money, money, money. When you renew, you're paying the renewal fee. The renewal fee is due May 15th to June 30th. Renewal period is May 15th to June 30th. They give you 45 days to log into your account and submit your credit card for $45 this year. Questions on this one? So Mel's still up, Cece came up, Shay's still on the board, Hill's up, Jen's on the board. Question number 3, what is the deadline for CE? Ten seconds. June 10th, June 10th, June 10th. What's the 18 months from licensure? Your post. Post and CE are two separate things, y'all. They're different departments down at the commission. Post is for newbies. CE is for all. June 10th is the deadline for CE. June 30th is the deadline to renew. June's a big month in real estate, North Carolina real estate. Questions? July 1st is when the year starts all over. New year, new CE. Mel's still on top. She's in fire this round. Cece's still up. Jen came up. Fabia's on the board. Liv is on the board. Or LV. Question number 4. In North Carolina, all real estate brokers must. I like this question. In North Carolina, all real estate brokers must include the firm's name in all of your advertisements. Otherwise, you're dealing with a blind ad. Remember, always remember, you guys, this will serve you well. Whose listing is it? Whose buyer is it? Whose brokerage services are you advertising under? You're under the umbrella of the firm. Who can tell me what's wrong with the blue one? There's one word that makes the blue one wrong. Yep. And that one word is the word current. What does current mean? Everybody show me. What does current mean? You've paid the fee. It has nothing to do with education. It has everything to do with money, with paying that renewal fee. Tricky, tricky. I get it. This is why we're here. What questions do I have? Mel and Cece are still up. Shay came up. Jen and Bobby are still on the board. Jenny is our highest climber this round. She's up three places. Question number 5. Under license law, a provisional broker is authorized to This is why we do what we do. This is my favorite Kahoot. Under license law, a provisional broker is authorized. You can list property for sale. You can work with a buyer. You can work under property management. It's all good as long as you are under the direct supervision of a broker in charge. Thank you, nobody, for saying the red one, because nobody has the authority to sign a contract on behalf of anybody. Brokers. We're not going to advertise under my name because it's not mine, it's the firm's. And then all commissions, bonuses, referral fees, all monies have to run through the firm. We can only be paid by our firm. How are they going to pay you? That's up to their compensation policy, their firm policy. Good job, you guys. If we were in person, I'd bring candy next time. But since we're not, y'all go get you some candy this afternoon. Go out and treat yourself to whatever your favorite candy bar is, or treat, Skittles, whatever. Questions on this one? Didn't budge. Cece's on fire. She's got 5 correct in a row. And the last one, how long from receipt does a provisional broker have to deliver trust funds to their bid? Careful. Trick question. PBs cannot walk around with somebody else's money. So how long? Immediately. Somebody hands you money as a PB to hang on to, get it to your BIC immediately. The 3 days of receipt or contract formation is how long the escrow agent has to deposit it once they've received it. Questions on this one? And thank you again, nobody, for saying the green one. I'll just deposit it in my account. I can hang on to it. True story. We got an email from the commission this past summer, maybe it was spring. There was enough complaints and concerns that they sent all of us across the state an email. That's rare that they email us. But we got an email spring, early summer, and said they had agents, and y'all, solution to a problem. Agents were allowing due diligence fees. They were allowing the buyer to cash app them the due diligence fee. And then from my account, I would write a check to the seller. Easy solution to a problem, right? No. If you're ever going to hold money for anybody, even if it's for a millisecond, if you're going to hold money for anybody, the only way you can hold it is in a trust account. So Cash App and you is not the easy solution. We got to come up with something else. Is everybody good with that? Sometimes we're in situations where we got to come up with, we call them creative solutions. Always reference license law and commission rule to make sure your creative solution is allowed. Questions? Let's see what we got. Third place podium winner is Ashley Bag, came out of nowhere. Popped up, good job. Second place is Cece. And then our first place is Nell. I got fourth and fifth runners up of Shay and Jen. Good Kahoot. Do I have questions? All right. Let's take 10. When we come back, I need everybody back. When we come back, safety, and then exam rules and expectations. So please watch your time, 10 minutes. I am taking attendance. Oops, Shauna, you're in. Melody, Haley, you're in. Joanna, everybody's in. Cheese. All right, first off, talking about agent safety. Maybe you've thought about safety, maybe you haven't. This is, I don't know, you're not going to be tested on safety, so put your pencil down and just relax for a second. But even though you're not tested on it, it's of my opinion and many others that safety is one of the more important topics that we talk about in this class. I certainly don't want to scare anybody, but I need you to be aware that you're putting yourselves out there to the public. You are inviting the public to contact you. Are there crazies in the public? You better believe there are. So agent safety is always and will always be number one. There is no amount of commission that is worth your safety. And if you don't believe me, just ask your family when we log out. And I bet you anything, they'll be willing to agree with me. So I just want to bring your attention to a couple things. What we're looking at, this is a publication from the Real Estate Commission, and it's this commission's safety guide. This is a PDF, and I'm putting this in the chat for you guys right now. So if you want a copy of this PDF, you're welcome to pull it up and download it so you have it for reference. If you don't get it now, that's fine. Just reach out to me and I'll be happy to send it to you. But this safety guide just kind of offers suggestions and things to consider when we're out there working with the public. And so many times, especially new agents, don't believe that things can happen to them. So I need you to put that aside. And gentlemen, you're no exception. Even though you may be a he, I still need you to practice safety measures, safety protocols at all times. So this little guide starts with some real life examples of agents that were victims to various safety measures. And this is what we want to avoid. And so this guide gives us some safety tips. Safety tip number one says, know who you're dealing with. Set up a protocol. When you meet somebody, may that be at your office or at a public place, when you meet somebody, have certain protocols in place. And remember, fair housing says, what we do for one, we do for all. So if your safety protocol is to make a copy of that person's driver's license, what you do for one, you do for all. It doesn't matter if you feel comfortable with them or not. You've made them feel different than everybody else. So set up your safety protocol, and your firm can help you, set up your own safety policies and make sure you practice it for everybody. If this buyer, for example, isn't willing to meet you at your office or a public place, if this buyer is unwilling to send you a copy of their driver's license, I'd have to question this buyer's sincerity in the property. Remember, you guys, you are the professional in this transaction, which means you lead the course. And it all starts with making sure you know who you're dealing with. Please, y'all, don't meet a stranger at a vacant property by yourself. Everybody promise me? Take somebody with you, may that be a family member or another agent. Never meet a stranger at a vacant property by yourself. And look, it's tempting. You're going to be on office duty. Somebody's going to call you and say, I'm at 123 Main Street. Can you show it to me? And it's going to be awfully tempting to slam down the phone and run out to 123 Main Street. But remember, you're the professional. You lead the course. I'd be happy to show you 123 Main Street. Why don't you come into the office first? Why don't you meet me at Starbucks? Buy them a coffee. What's a good tool that I have that I need to go over that might require me to meet everybody in a public place or at the office? I'm seeing mouths move. Can't we use our working with real estate agent disclosure as an excuse? Before I show you this property, I got to talk to you about working with agents in North Carolina. use that as a tool. So know who you're dealing with. Safety step number 2, tell somebody who are you with, where you're going. Maybe you let a peer know. I'm showing these 3 properties today about this time. Maybe you let your family know. I'm out with a buyer today. We're going to look at 5 properties, and this is our schedule. If you're doing an open house, let somebody know where you are, who you're going to be with, so they can help keep up with you. I hate to say it, but should you go missing, if somebody has your itinerary, you're much easier to find. You're much easier to track down. Safety tip number 3. Do we ever put these things down anyway? I mean, these things are like tethered to us, right? So why are we putting them down now? During showings, have them on your person. I'm not telling you to be on your phone when you're with buyers or sellers, but have your phone handy. We'll talk about open houses in just a second, but I know for me personally, when I'm doing an open house, before I unlock the front door and let the public in, I go through the home and make sure I don't have any dead spots on my phone. So if there's that corner of the living room or the basement where I don't have a service, guess where I'm not going during the open house? I have that thing handy in my pocket. A lot of times we need an app on our phone to access the property. So if it's on an electronic box, also known as an e-box, you have to pay for the app, all part of your new agent orientation. And you have a code that you use to get the key to walk in the front door. So I say that to say it's not weird for us to have our phones. It's not rude for us to have our phones out because I need it to get in the front door in most cases. But keep your cell phone handy. Conduct a safe open house. It's kind of funny to think about it, but when we're doing open houses, we're pretty much sitting ducks, aren't we? We're telling the whole world, I'm going to be at this big empty house all by myself on Sunday from 2 to 4. Come see me. I'm advertising it. I'm letting everybody know that I'll be there. Open houses are always have been, and always will be a big concern. So again, make sure you don't have any dead spots for your phone. When I do an open house, me personally, I keep myself positioned at the front door so I can greet everybody that comes in and I can thank those that are leaving. It's awfully hard to get me away from the front door. Part of that is because I want to greet everybody that comes in, but another part of that, I see you coming down the street long before you get there. I see you when you're getting out of the car. I've already scoped you out. I know what you look like, right? We can know who's coming and going. All other doors in my open house remain locked. It's not like I got all doors unlocked for people, free for all for people to come and go. So have control over the route, have control over what guests, where guests can access and exit. In addition to your phone, have your car key with you. In the event it goes down, the whole objective is to get away. Does anybody's key or fob have the alarm on it? What a great thing to have handy should you need to be. So you can set off your alarm on your phone. That'll attract attention. Also with your car, if at all possible, park on the street. If at all possible. Now, not everywhere offers street parking. If you do have to park in the driveway, I would park in a way that you could get out. Don't let yourself get blocked in. And that's a good point. Car keys can also be used as a weapon. Anything within reach, if need be, can be used as a weapon. Speaking of weapons, some of you may have or might be considering getting your concealed carry permit. If you have or will get your CCP, the question is, can I carry? And the answer is yes, as long as you have your concealed carry. Your firm may have a policy about whether or not you can carry at the office. But when you're out with buyers and sellers, when you're out doing an open house, if you have your CCP, if you don't, get mace. Get a taser, get something, have something on you. One year for Christmas, I got a flashlight / taser. It looks like a flashlight until I hit that magic button. Is it weird for a real estate agent to run around with a flashlight? No, it looks perfectly normal. If you can bring somebody to your open house to sit with you, that's great. It's been my experience, open houses go one way or another. You meet 12 groups of people, or you sit there for 2 hours and don't see a soul. So always take something to do. If you can take somebody with you, it'll help the time go by fast. If they're licensed, they can help you sell the house. If they're not, we need to tell them that they need to keep their mouth shut because they're not licensed. Their job is to be company for me. So you can take an unlicensed person with you. They just need to understand their role. Also, with open houses, we need to have conversations with the sellers and make sure that the sellers lock up valuables, prescription medications. Sellers shouldn't be leaving prescription meds in the bathroom medicine cabinet or in the counter above the kitchen sink. You know where everybody keeps their prescription meds? Near the sink. So put them somewhere else. Remember, my open house, I'm positioned at the front door, which means people are going through the house without me watching them. And one of the best things I can do to protect my sellers is to tell them to put these valuables up. They got to pack anyway. They're moving anyway. Why not go ahead and pack up some of these things? We don't want anybody to have reason to make plans to come back later and take what they saw that they liked at the open house. I wish I could tell you everybody that comes in an open house is good, honest people, but I'm not going to lie to you. So have the conversation with your sellers so they can protect their stuff. Let them know that you may not be able to be with everybody as they're going through the open house. Safety tip number 5 tells us to have a distress code. And this is going to be with your firm's policy. Your firm may have a distress code. We'll want you to get familiar with that. Some way you can call, somebody you can reach out to if you feel uncomfortable, if you feel that you're in a situation that's not making you feel good. So go over your firm's distress code, buddy up with somebody, find somebody. You guys new? Find somebody that's new as well. You guys can team up and start your business together. Safety tip number 6, don't make your personal marketing too personal. At some point, you're going to have to write a profile for your website. And honestly, as a new licensee, that's one of the hard things you're going to have to do is write your own profile. It's really hard to talk nice about yourself sometimes, isn't it? So writing that profile has challenges. You can get help, but just don't make it too personal. I think it's okay. If you're writing a profile, what you're wanting to do is having somebody connect with you online. So we want to say enough to make the connection, but we don't want to give away too much personal information. If you're reading my profile, you might see that I graduated from UNCG. And somebody's going to say, I graduated from UNCG. Go Spartans, go. And now we have that connection. I'm okay if you want to mention kids. If you are, just don't get too specific with your kids, y'all. I think you can say kids and we have a connection, but I would not give too much information out about your kids. Safety tip number 7, have a buddy. There's safety in numbers, right? So if you are going to meet that buyer for the first time in a vacant property by yourself, take somebody with you, somebody from your office. I know my husband has come with me on several occasions for showings. He stays in the car. He doesn't get in my way, but you know what? He's there and they see him. So take somebody with you. Dress for safety. I wouldn't wear flashy jewelry when you're meeting strangers because what's that tell strangers? Hey, she's got flashy or he's got flashy jewelry. Ladies, I know we love our stilettos. Careful about wearing those when we're showing property. It's going to be awfully hard to run away. It's awfully hard to be in land. What if you're in the backyard and it just rained? You're going to sink in with your stilettos. So maybe you wear your flats just for the showing. You can put your stilettos back on afterwards. Danger is not always easy to identify. So in other words, I don't think the attacker is going to be wearing their "I'm bad news" t-shirt. They're going to look like anybody else. And with all of this being said, if you don't hear anything else, the number one piece of advice I have to offer you is listen to your gut. We were born, we were ingrained with this fight or flight. And when your gut tells you to get the heck out, then you need to get the heck out. Don't question your intuition. Don't question that gut. When it says run, run. Vehicle safety. Again, the big thing here is, if at all possible, don't allow yourself to be blocked in. Driveways, dead end streets. If nothing else, turn around so you can throw it and drive and get out if need be. I just think a good rule of thumb here is have an exit plan just in case. And not allowing yourself to be blocked in is also good advice. Safety tip number 11 when you're showing the property. Let the buyers go into the house first. Let the buyers go into the room first. Let the buyers go up and down the stairs first. We want them to walk through the property for the experience. And if I'm ahead of them, I'm getting in the way. It's awfully hard for you to imagine yourself living here when I'm standing in the middle of the room. So follow them for the perception so they can better imagine themselves living there. But then you're also not going to get yourself blocked in. I never want you guys to be blocked in. May that be in your car or in the property when you're showing. Safety tip 12 is our fight or flight. And then some additional information. It's a lot to think about. Again, your firm will go over this with you because we always want you guys to be safe. I think every single one of you on this call, every single one of you should consider taking a self-defense class, learn some basic maneuvers to get away should you ever be in a situation. Your local, maybe your local rec center or your dojo karate studio, those would be good places to start for a self-defense class. Just some basic mechanisms. Again, my objective is to get away. When I leave the front door, I want to know that I'm coming home tonight having dinner with my family. And that's what it's all about. That's what we mean by safety. You've always got to be aware. You've always got to practice safety. What other thoughts do we have about safety? Question comes in, if you have your concealed carry, do you have to disclose to the people that you have one, that you're carrying? You don't have to disclose. Before you run out and get your concealed carry, we need you to learn how to handle a gun. You need to know what you're doing with a gun. And you know what comes with gun training? Number one is always safety first. Don't pick it up if you don't know what you're doing. Fair enough? And if you're not comfortable with a gun, that's great. Get you something else. Mace, that flashlight with a taser, something. I got another year for Christmas. It's called the Bird, I think. And it's this little, it looks like a keychain. And when I pop the pin, it makes this shrieking noise. It's going to get somebody's attention. There's so many things out there. But like we just said, you guys, your keys, you can put your keys between your fingers and now you got a weapon. Anything around you can be used as a weapon. Again, for that whole objective, it's all about getting away. Other questions or thoughts? Again, bottom line, we just want you guys to come home every night and be with your families. And if you're ever in a situation, run. Question it later. Run now. I had, I don't know, I had an open house many years ago. A gentleman came in. Do you guys ever meet somebody and just get a weird feeling, something about it? Just so I had this feeling with this gentleman. And then he just, as he was kind of going through the open house, he just made a couple comments that I just found odd. I don't know another way to put that. It was just odd. And I'll be honest with you guys, I was like this close to, oh no, I have an emergency phone call. I need to walk out on the front porch. I was this close, y'all, because I was just not feeling. But about that time, another couple came in. So now I feel better because I have multiple people in the home. That was me personally. After that gentleman left, y'all know how easy I second guess myself. I said, Julie, you're so silly. Why did you react like that? But you know what? That was my gut. That was my gut telling me that something just didn't feel right. Then he started making those odd comments. He left before the couple did. Anything else? Safety. You guys got the brochure if you want it. Everybody see it in the chat if you like it. No requirement, but just there for your information. All right, I need everybody's attention. If I can't see you, I need to see you. If I can't see you, then I can only assume that you're not aware of the exam rules and expectations. So to be certain, I'm going to take attendance again, so we can make sure that I see you. And I like to start with this guy because I love this guy. Do y'all feel this guy's pain yet? This guy's about as for real as they get, isn't he? You ever feel like him? I remember I did. So these real estate exams, this conversation is for our exam Thursday morning. So when we log in together on Thursday morning, it is all about the test. And we have a couple things that we need to do before we can begin the exam. And I need everybody on the same page on Thursday, on exam day. So first off, I'm going to log in a little bit early on Thursday because I have to check you in. And quite frankly, this is not a big class. So let me make a quick edit here because I don't need that much time. So instead of 8:30, let me just say I will log in Thursday morning at 8:40. 20 minutes is enough time to check everybody in. If you can check in at 8:40 so I can get you checked in, I would appreciate that. And your peers would as well, because we cannot start the exam until I have everybody checked in. So if you're not coming till 9, you're delaying your peers. So I'll be here at 8:40 so I can get you checked in. There's not that many of us, so we can do it pretty quickly. But we're going to have to spend some one-on-one time together during the check-in process, because during the check-in process, I need to see some things. It's like show and tell. So during the check-in process, I need to see your basic calculator. You cannot use your phone on Thursday. Your phone has Google on it. You cannot use a calculator that stores formulas. Y'all remember from high school, we had those TI-82s? You cannot use that. Everybody please acknowledge that you have or will get a basic calculator. Do not show up on Thursday and say, Julie, I don't have one. Can I just use my phone? The answer is no, which means you'll be taking this test without a calculator. You can have pen, pencil, some kind of writing utensil. I don't care. Purple crayon makes no difference to me. You bring 2 pieces of blank scratch paper. Part of your check-in process is showing me those 2 pieces front and back so I can verify that they're blank. They must stay blank until the exam begins. Once the exam begins, you can do whatever you want to with them, but they have to stay blank until we begin. I ask you to start with 2 because, to my knowledge, when you go to your state exam, you know how many pieces of blank scratch paper they're going to give you to begin with? They're going to give you 2. If you need more than 2, just reach out to me during the exam and I will let you have more than 2. And I will talk in just a second about how you can communicate with me during the exam. So everybody good? We're going to start with 2. Don't bring 3. We're going to start with 2. And if you need more, I'll let you get it. If at all possible, if you're on a laptop or a tablet, you can shift your device around so I can see your blank table space. Maybe be on the kitchen table or the desk, but I need to see that your area is blank. If you're on a desktop, you obviously can't move it around. So we're going to do the honor system. I'll let you have drinks, snacks, cough drops, mints, gum, whatever you need. We're going to talk about making sure you eat breakfast before this test starts. But anything you need, I'm fine with. I need to know that your books and notebooks are closed, and preferably closed near you. I don't want your books in the bathroom because I do let you take bathroom breaks. And I will talk about that in just a second as well. So ideally you can say, Julie, here's my book and my notebooks. I'm putting these down right here. And if during the test I see you going this way, I know you're going towards your book. The other thing I ask is that your phone is off during the exam. Does that say silent? Does that say vibrate? I prefer your phone to be off. One is going to eliminate distractions. If your phone's on and it's sitting near you and it lights up, what do? We grab it and see who's calling, grab it and see who's texting. Turn it off so you can focus just on this exam. And also so we know you're not using Google to look stuff up. We don't turn our phones off that often, right? So before we start the check-in, I ask that you go ahead and power it down instead of trying to turn it off during the check-in. That's just going to take us time. So during the check-in, I should be able to see you hit this button on the side and see that it's off. Is everybody with me? What am I doing here now? Oh my, I'm calling 911. Hang on, you guys. I guess I hit it one too many times. No, I think we're cool. If the cops show up in a minute, we know what's up, right? All right. So I just need to see that it is off again. Turn it off before you get here. And then that way we don't have to wait for you to power your phone down. This is our show and tell. This is our one-on-one time. This is what I need to do with each of you before I can begin the exam. Questions on this? You guys all look great where you at right now. I need to be able to see you. I don't want any virtual backgrounds. I can't have dimly lit spaces. I need to know if there's somebody behind you. And if you have a virtual background on, there could be people behind you. So we need all this off. Everybody make sure you tell your family on test day they need to leave you alone. Because if I see you talking to somebody else in the room, I can only assume that you're talking about the test. That's considered cheating. And I have instructions to remove your exam until we get this hashed out. Don't give me reason to take your test, please. So be in a room by yourself. Everybody's leaving you alone. I also need you guys to close all your tabs. You're going to log on to Zoom like we always do. When we first start the exam, Zoom should be the only thing open. Log out of your emails, close your other tabs, close out Amazon. I'm trying for you guys not to be distracted during your exam. So when you come in Thursday morning, the only thing you have open is Zoom. Close your email once you open Zoom. When the exam begins, you'll have 2 tabs open. Zoom so I can watch you. Class marker so you can watch the test. I will not be sharing my screen on test day, which means there's nothing for you guys to look at but the test. I watch you, you watch your exam. This is important. When the exam begins, I am your only friend. Once the exam begins, I am the only person that you can communicate with. And the only way you can communicate with me is through direct message. Before we begin, I'll have you guys set your chats to private. And if you need anything during the exam, more scratch paper, a bathroom break, a bottle of water, adjust the temperature. If you need anything during your exam, you communicate with me via direct message. I will not tolerate you guys unmuting and disrupting your peers. Again, I'm trying really hard to eliminate distractions. And the fact that you need a bottle of water is a distraction to your peers. So help your peers not be distracted. Anything you need once the exam begins, you communicate with me and only me. Questions so far? So I get everybody checked in. We're ready to begin. I will put the link to the exam in Zoom. So when we're ready, the link for the exam will be put in Zoom in the chat. You click on the link or copy and paste. It's safe to say if you're going to have problems, it happens when you click on the link. Maybe your camera goes out. Maybe it doesn't open. I don't know. I can't tell you what might happen, but what I do know is we will get through it. So if you click, if it's not working, if something doesn't seem right, reach out to me via direct message and we will get through it. I promise. You get 4.5 hours. There's 142 questions. In order to pass my exam, you have to make a 75%. And when you're done, you're done. You hit submit. It says, are you sure? You say yes, and boom, there it is. There's your score. 75% you passed. Under 75% we'll talk about in a second. Once you see your score, I too will get your score, so we'll both see it. Once you see your score, you're free to go. You can log out. You don't need my permission. You don't need me to excuse you. Once you see your score, you're free to go. Be patient because Elaine will be in touch with you when everybody's finished. I'll talk more about that in a second.
Miss Julie, I have a question. I think I told you last because I've took this over, but I read the question to myself. I'm like a talkative, will
Yep.
that be okay? I think last time you told me yes, you'll know, or
Yeah, and Lynn, just make sure I can see the difference between you reading the question to yourself versus talking to somebody else in the room. So if
okay.
you're reading the question to yourself, make sure I can tell that you're kind of mumbling. You know what I'm saying? If I see you looking up and talking over there, I know you're not reading to yourself. Does that make sense, you guys? So if you have to read out loud, I'm okay with that. Hey, I get it. But just make sure I can tell that you're reading, you're mumbling the question. And guys, this will serve you well for your state exam because your state exam, there's other people in the room. So you can move your mouth, but you can't be out loud because then you'll distract the others and they'll probably take your state exam from you. Thank you, Lynn, for asking me that. So we get everybody checked in. The chat goes in, or excuse me, the link goes in Zoom. Everybody clicks on the link. You put in your name and your email. By the way, this Classmarker is the same program you guys took your midterm on. So your midterm gave you really good practice of bookmarking a question, skipping a question, making sure when you're done that everything is answered. If you want refresher on Classmarker, see that email from Lane with our Zoom link. It has a Classmarker tutorial. So if you want a refresher on how Classmarker works, I encourage you to watch that tutorial in your email from Lane before the exam. So you put in your name and your email address, and then you see this. This says you're not going to cheat. You're not going to use notebooks or textbooks. You're not going to use flashcards. This is a closed book exam. You cannot discuss this exam when it's over with anyone. They do not want you discussing the particular questions with anybody, and that includes Lane and I. Please don't call me and start quoting a question. I'm going to wonder if you copied it. Everybody with me? You cannot talk about this test. You cannot talk about your state exam. The last sentence of this, anyone in violation will receive a failing grade and be reported to the North Carolina Real Estate Commission for further inquiry. If I suspect you're cheating in any way, I'm not going to deal with it. Lane's not going to deal with it. We're going to let you take it up with the North Carolina Real Estate Commission. So you click submit. It says, are you sure? And you say yes. And your score is a 75% or more. Congratulations. You passed the end of class exam. Lane will be in touch with your certificate of completion. Certificate of completion is what you need to submit your application. Even if you're not ready to submit your application just yet, still keep that email from Lane, because whenever you do submit your application, you need that certificate of completion. Check your spam. I don't know why, but sometimes Lane winds up in your spam. And y'all, please be patient with Lane. She's a busy girl. She will get to you guys Thursday afternoon. I'm going to say Friday morning at the latest. But please be patient with Lane. If all of you are calling Lane, then she can't process because she's too busy answering the phone. So please be patient with Lane. I promise you, she will get with you. If you do not pass the exam on Thursday, but you make at least a 50%, you are eligible for the retake on November 23rd. Lane will be in touch about the details of the retake. So if you pass, Lane will be in touch. If you're eligible for the retake, Lane will be in touch. She will tell you, I believe the exam's at 9, but the retake's at 9, but I don't want you guys to hold me to that. I'm not available to give the retake. So Lane or somebody else at Carolina School will, and she'll have to send you their Zoom link. So if you don't pass, but you make at least 50%, you get a free second chance. How many times in life can you say that? Not all schools offer a retake. We do. If on Thursday you don't make a 50%, you're not eligible for the retake. If you don't pass the retake, then you need to sign up for another class. You've got to keep going until you get your certificate of completion. The only way to get your certificate of completion is to pass the end of class exam, whether that's mine or another instructor's, another school's. So if you don't pass the retake, if you don't pass the exam, it's okay. Take a big deep breath. If you really want a career in real estate, you'll sign up for the next available class while it's all still fresh in your mind, and Lane will be in touch. So did we hear what I just said? If you pass, Lane will be in touch. If you're eligible for the retake, Lane will be in touch. If you fail, Lane will be in touch. One way or another, you will hear from Lane. Please be patient with her. Please. Questions? May I offer some advice? Tips and tricks, if you will. When we're taking this exam, the number one piece of advice I can offer you is to breathe. If you feel yourself getting worked up, if you look at a question, you go, oh my God, I've never seen this before in my entire life. Stop and take a few big deep breaths. Anybody else do yoga? You know what a big thing about yoga is? Breathing and getting control of your breath. If you're all, you're not doing yourself any good. You're not focused. So if you feel yourself getting overwhelmed, it's okay to put your pencil down, close your eyes, and take a few big deep breaths to get yourself grounded. After you breathe, the next big piece of advice I have for you is to read. Read and breathe, breathe and read. Two best pieces of advice I can offer you right here. Have we done enough practice questions to know that every single word means something? If you skip a word, you've skipped something. So take your time, read the entire question and all of the answer choices. If you read a question that you don't know the answer to, that's a good candidate to bookmark and come back to where you can spend more time on it. Another benefit of bookmarking, it might be that a future question triggers something in your mind. So maybe you forgot about 13, but you get to 26 and you're like, oh yeah, that's right. So kind of use the test to help yourself. Take advantage of that bookmark feature. And then make sure that everything is answered before you hit submit. Other pieces of advice. How many of you have changed an answer from right to wrong? Stop it. Stop it. Y'all stop it. Don't change an answer unless you are like 5,000% sure that it's wrong. Remember that gut instinct we just talked about? If you read it and your gut says C, there's a really good chance that that's the answer. If your gut's not saying anything, those are the ones that you bookmark. So you can come in at the end and spend more time. Once upon a time ago, we had to grade these tests by hand. Lane and I did. And I could see, because you guys, you know, the little Scantrons and you colored in the A, B, C, or D, you colored in the bubbles. Y'all know how many times I saw the right answer erased for a wrong answer? You know how many times people have failed this test because they changed too many answers? Stop it. Before you hit submit, make sure everything's answered. Again, a feature in Classmarker, you have the option to click on, I think it's just something like view all answers, but you can go through and make sure they all say answered, no more a bookmark, and none are unanswered. Again, might not be a bad idea just to watch, save that tutorial on Classmarker to refresh yourself and make sure you're utilizing Classmarker to its full capacity. Whenever you get to a question and all 4 answer choices are numbers, don't even read it. Just bookmark it. Don't waste your time reading it. Save the math for last. Make sure everything else is answered and do the math last. And of the math, the how much does your buyer have to bring to closing is the last. Also in Classmarker, they have a countdown clock from 4.5 minutes. So take your time, but watch your time. Keep a half an eye on that clock, because after 4.5 hours, the exam ends, whether you have everything answered or not. I will, about 10-15 minutes before the end, I'll unmute myself and try to gently let you know there's only 10-15 minutes left. So if nothing else, you can just go in and throw in B or C or whatever your favorite is. At least if you throw something in, you got a 25% chance of getting it right. Yes, ma'am, Lynn.
Right. I forgot about my watch, the Apple Watch. So we don't need to wear those, right? Our iPhone watches.
That's a great point, Lynn. Thank you. And preferably not, because, so yeah, I'd leave that off in the other room with your phone. Thank you. More advice? I'm just full of advice. Between now and Thursday morning, y'all don't spend all your waking time studying. I know this is probably what we're doing today and all day tomorrow, and maybe even Thursday morning at 5 o'clock. That's fine if you want to look things over, but y'all do something else between now and then other than study. There is such a thing as overstudying. If you spend all day tomorrow studying, if you don't pull an all-nighter Wednesday night, you're going to be over it before it ever begins. So give yourself a break at some point tomorrow. Go out and get some fresh air. Wednesday night, get a good night's sleep. Seriously, this is not the time to pull an overnighter, or an all-nighter, I should say. Get you a good night's sleep. Y'all, at some point Wednesday night, you've got to put the book down. At some point Wednesday night, you've got to know that you know what you know. You know? And you got to get that good night's sleep. Do whatever you do to relax. Thursday morning, get something on your stomach. You're not going to do yourselves any good trying to take a 4.5-hour test on an empty stomach. You're going to be distracted by the gurgling. Now, I wouldn't recommend a Golden Corral buffet or anything, but get you something. And again, if you need snacks during the exam, I'm fine with that. I'm fine. But all in all, Carolina School of Real Estate wishes the best for you guys. The best not just for your end of class exam, but remember the ultimate goal is that state exam. So let me hear from you guys through your progress, your journey, as you finish with us and you go on to your state exam. That's honestly why I do what I do, so I can get a text from you guys. Hey, Julie, guess what I did today? And I will celebrate with you, because I've been there and I know what this means to get that state exam. So keep that goal in mind.
Miss
The
Julie,
other
I wanted,
thing, yeah, Lynn,
oh,
I'm
I'm
sorry.
so sorry. I just
No,
wanted one more thing because I wrote it down the other day. You had told us the chapters that we need to, that are heavily tested. Well, can you tell me those one more time? I just want to, those are the ones I'm going to go over.
7, 8, 9, and 10. Agency and contracts. At some point when you guys are done as well, you'll get an email from Lane with a survey. Appreciate you guys taking a few minutes and doing the survey. It's anonymous, so you can be very honest. But that survey is what helps the school grow. It's what helps me grow. So I appreciate the time for your feedback. We do look at that. We do take your comments into consideration. On test day, on Thursday, I'm not going to be sharing, so we're all going to look like this. So what I want you guys to do, if you look at your screen, at your Zoom, does everybody see everybody? We look like a big Brady Bunch family right now. Okay. So if you will, at the top of that screen, you got your close out, minimize, and little button. Click on that little button to minimize Zoom. Once you begin your test, you can minimize Zoom and then just kind of tuck it off to the side. So you're not looking at your peers, you're just looking on your test. And the only time you should have to open Zoom during the test is if you need to communicate with me. Otherwise, you just should be on your exams. Does everybody see that? You can make it little and then kind of just tuck it off to the side. Because I don't want y'all watching your peers, because that's going to be distracting. So eliminating distractions on the exam is tough enough, but on Zoom, it's even tougher. And I know a lot of you worked really hard to be here. So I'm going to do whatever I can in my power to eliminate those distractions. Any questions about the exam? I can answer questions up until the time that I put the link in the chat. Don't ask me a question about the test, y'all. I can't answer that. That's too late. I'm around tomorrow. I'm around, or yeah, this afternoon. I'm around on Wednesday. Q&A time is close to being over. All right. This is what's up. I still have 3 units, 13, 16, and 18. I can probably blow through them in about an hour and a half or so. As far as I'm concerned, class time and attendance time is over. We stopped taking attendance at 12:55. Make a note. I'm going to keep recording. I'm going to go through and do units 13, 16, and 18. Of the 3 units, you can expect to see a test question, which is why I've saved these for the very end. I'm going to keep recording so you guys have the material. You're welcome to stay, but you're not required to. If you want to stay, I'm going to take like 3 minutes and go get me some more water. And we'll go through those 3 units real quick. If you want to go, have a good afternoon. And we'll see you guys Thursday morning to get started. So let me, if you're sticking around, I just need to run, like I said, and get some more water. And we're going to start with 13 as soon as I do that, which is, Sean, it's at the top right. So you got the closeout button. It should be above your, where your, all of your, and if you're Apple, it might be your red light, green light, yellow light. I don't know Apple products, but it might be that your, whatever your minimize button is. Yeah, is what you're looking for. So we are going to do 13 first. 13 is our property insurance, homeowners insurance. So let me go get water real quick, and then we'll do insurance. Okay. Thank you for that. Insurance. This is the unit we get to put on our homeowner's insurance hat. Maybe you didn't know you had one of those, but we're going to go over some very basics about property insurance briefly. Go over some basics about property insurance. So there's a couple different types of homeowners insurance that we're going to discuss. We're going to explain some insurance issues. And to start this unit, unit 13 on page 372, we have to define some words. Insurance is the bilateral agreement between the two parties. Insurance is the contract. It's the agreement between the two parties. The two parties are the insurer and the insured. The insurer is the insurance company. The insured is the homeowner. And what insurance does, the bilateral agreement, the insurer agrees to cover the insured in the event something bad happens. And in exchange, the insured is going to pay the insurer. When it comes to homeowners insurance, if a lender is involved, homeowners insurance is required, period, end of story. You're not going to get loan approval without insurance. If you drop your insurance, they could foreclose on you. This is part of your agreement, is that you will remain insured as long as you owe money to the lender. If it's a cash buyer or you pay that loan off, insurance is highly recommended. The insured will pay a premium. That premium is the consumer's cost. The insured cost, what they're paying for that coverage from the insurer. Couple different types of homeowners insurance. Property insurance is also known as casualty insurance. This is what protects the insured from damage to the property. If there is damage to the property, that property insurance will cover them. Liability insurance protects the insured from losses or damages caused by third parties. So if somebody that doesn't live there comes over and they damage the property, if they hurt themselves, liability insurance will cover that. What most of us have is a package insurance policy, which is property and liability. So the package combines the two. The lender requires a certain minimum for the insurance policy. So part of the buyer's due diligence is going to be to select a policy. And then they'll have to approve it. The lender will have to approve that policy and make sure their minimum requirement is covered. And most minimum requirements are under this package insurance that lenders want to see required. Your book talks about a couple different types of policies, and I'm not going over all the policies, but we are going to hit a few of the highlights. And probably the most common policy, the one that we see the most often in homeowners insurance, is the HO3 policy. This, generally speaking, is the one that provides the lenders with the minimum coverage in order for them to improve the policy and thus to approve the loan. So HO3 is the most common homeowners insurance. It satisfies the lender's criteria. And it also provides the insured with the greatest amount of protection, that package liability, the property and the third parties. It's kind of an FYI. There's also an HO4 policy. This is our renters insurance. So tenants need to have insurance on their stuff. The homeowner, the landlord, will have the property insured, but the tenants need insurance on their stuff. That's at HO4. They can only insure what they own. What they own is personal property. Again, the landlord will have a homeowner's insurance policy, probably an HO3, for the property, the structure. Tenants have one for their stuff. Another policy is the HO6. This is the policy for our condominium owners. Remember, condo owners don't own the structure. Condo owners just own from sheetrock to sheetrock. So they have a specialized policy for the fixtures and their stuff. HO6 is sometimes called a walls in policy, walls in, because they're covering everything from the wall in. Defining some more words. The condition is a limitation on coverage. There's not everything is covered. There may be limitations. That limitation would be a condition. The best example we have of a condition is vacant properties. We're going to talk about vacant properties in just 1 second. An endorsement, you may hear referred to as a rider. This is something that's covered that's not normally covered. So something rare or valuable, grandma's antiques, for example, you may want to take out an endorsement or a rider to specifically cover that rare or valuable item. Insurance policies also have an exclusion. And what most homeowners insurance policy exclude is loss due to some kind of specific event. For example, not many of us are covered for acts of war or terrorism. That's an exclusion. So loss due to a specific event. Whenever you apply for homeowners insurance, they're going to go through a database and see claims, previous claims on the property and the people. And if the property or the people have a history of claims, your policy, your premium might be a little bit higher. So if the property's had a lot of claims, you may have a higher premium. If the individual has a lot of claims, they may have a higher premium. And all insurance agents have a database that they can look at those claims And that database is your CLUE report. CLUE stands for Comprehensive Loss Underwriting Exchange. And this is the database that allows insurance agents to look at the people and the property's claim history. They'll go back 7 years and help them determine the premium, help them determine the cost of coverage. This is why we want buyers to shop around for homeowners insurance while we're still in due diligence. Because if their premium is so high because of past claims, their premium is so high that they're not going to get loan approval, the best we can do is find out in due diligence. We'll have to terminate and get your buyer their earnest money back. Let's talk about vacant versus unoccupied properties. First off, the distinction between the two. A vacant property is one that's empty. The people and the stuff are gone. Unoccupied means the people are gone, but the stuff is still there. Vacant properties are at a higher risk of theft, vandalism, because it's vacant, it's unoccupied. The people aren't there, nor are they threatening to come back. Listing agents, at some point before settlement, if they haven't already, your sellers need to move out. And if it's the day or two before settlement, whatever, I'm not worried about it. If it's a week or weeks, months before settlement, we need to encourage our sellers to report the property as vacant to their insurance company. Now, when they do that, there's a really good chance that their premium will go up for that time. But guys, here's the deal. If the home is vacant, owners didn't report that it was vacant, and theft or vandalism happened, there's a good chance that the insurance company won't cover it because they didn't know it was vacant. Higher risk. You guys hear on the news every once in a while, somebody got caught trying to steal the copper wiring out of a home. That doesn't happen in an occupied home as much. That tends to happen in a vacant one. So it must be reported. All I can do as the listing agent is encourage them in writing, document that to report it. I can't make them pick up the phone and call their insurance agent, but I can talk to them about the importance of reporting it as vacant. And I need you guys to document that conversation, because if it goes down, I want to make sure you guys are covered. No matter when the sellers move out, remember, it's still the seller's property until that deed changes hands. So whether the sellers are living there or not, while we're under contract, there's a risk of loss provision and our offer to purchase and contract, OTP and C, offer to purchase and contract. And what that risk of loss says is that the risk is on the seller, and they need to maintain homeowners insurance until that deed changes hands. So listing agents, make sure your sellers know that they can cancel their policy once the deed records. There's a common misconception that the home is doubly insured on closing day because the sellers have a policy ending, the buyers have a policy beginning. But the truth is, we're only going to cover the owner. So if the house burns down on settlement day, it's going to come to the date and time stamp that the deed was recorded. If the house burns down before the deed's recorded, the seller's insurance will kick in. If it burns down after, now the buyer, the new owner's insurance will kick in. And insurance policies aren't going to do anything until they get that report from the fire marshal that told them exactly what time. That's correct. Don't worry about 4 or 5. If you want to look it up, it's in your book. Just trying to help you out and hit the highlights here. If the house burns down or the tree falls on the home or the house is majorly destroyed or damaged while we're under contract, the risk of loss provision in standard form 2T gives the buyer options. If the house burns down while we're under contract, the buyer can terminate. And the contract says they'll get their earnest money and due diligence back. The buyer's other option is to not terminate, proceed with closing, and then upon closing, collect the insurance proceeds from the seller's insurance to rebuild. Buyer's agents, you're under contract, the house burns down, your buyer's going to look at you and say, what should I do? Pull that paragraph out in the contract and read it to them, let them know their choices. And they're going to say, okay, but which one should I do? We need to get them to their attorney to talk about those legal ramifications of choosing either one. All we need to know is they have choices. So let's bring this home. Insurance agent hat off, broker hat back on. What's all this mean for us? We need to talk to our property owners, talk to your sellers, make sure that they have their home status vacant, unoccupied, make sure that they're up to date with their insurance company. Just in case something happens, we want them to be properly insured. And listing agents, make sure your seller knows. Don't assume that they know. Make sure that they know. I had an aha moment early in my sales career, luckily. We went under contract and the seller's immediate reaction, I said, congratulations, you're under contract. And the seller immediately said, awesome, I'm going to cancel my homeowner's insurance. No. It's still yours until that deed changes hands. So they need to maintain their insurance policy until it's not theirs anymore. Also, when discussing insurance, we may have a situation. Possession typically happens when the deed records. It's usually when the buyer possession on closing, that deed records is when the buyer is going to get keys and access to the property. But we may have a couple situations where possession does not happen at closing. We may have a buyer possession before closing, meaning they move in before the deed records. We may also deal with a seller possession after closing, which means the deed records and the seller remains. In either one of these situations, one party is acting as the landlord and has to have homeowner's insurance. The other party is acting as the tenant and has to have renter's insurance. Now we have forms for both of these situations. And in both of these situations, it starts with a big red warning telling the parties that before they sign this, before they agree to do it, they need to talk to their insurance company to make sure that they're properly covered, homeowners or renters insurance. So the form helps us out in making sure that we get that get everybody properly covered. In addition to homeowners insurance and renters insurance, something else that might pop up is flood insurance. If the property is in a flood zone, then the lender may require flood insurance. Flood insurance is regulated by FEMA. FEMA is our Federal Emergency Management Agency company. Every homeowner's insurance agent is different. They all offer different policies at different rates. They can set their rates, they can set their own policy. With flood insurance, it all comes from FEMA. So no matter what insurance company they're going through, flood insurance is going to look the same. The insurance agents can't adjust that because it's a federal thing. So what they're shopping around for is homeowners insurance. And FEMA kind of has this algorithm. If the property's in a flood zone, again, they're not necessarily paying insurance. There's a lot of other factors that are determined. And if you will, turn with me to page 378. And on 378, the insurance agent, no matter who they are, State Farm, Progressive, Geico, doesn't matter. They're going to use this algorithm for flood insurance. And they're going to plug in this information. What year was the building constructed? What's its occupancy? Is it residential or commercial? How many floors are there? Where's the stuff? What's the flood risk? What's the location to the lowest floor that could be flooded? And deductible and amount of the building and the contents coverage. So they plug this information in to their system, and then beep, boop, boop, FEMA generates an amount that this property will be charged for flood insurance. So we shop around for homeowners insurance, but flood insurance pretty much is what it is. So FEMA designates as flood hazards. These are areas that are just prone to flooding. Maybe every time it rains, it floods, in which case FEMA will probably work with the community to try to reduce, because we can't have flooding every single time it rains. But we also know those quick, swift spring thunderstorms that pop up out of nowhere, those can cause flooding as well. So it's based on the property, it's based on how often it floods, the risk, the severity. And again, FEMA comes up with the amount of flood insurance. I think the further east you go, the more likely you're to deal with flood insurance. But guys, if I'm helping my buyers buy a property along a creek or a river or on a lake or a pond, it could be susceptible to flooding. So while I'm not FEMA and I'm not the insurance agent, I am perfectly capable of looking at a FEMA map, which we'll see in a second, to give my buyers the heads up. To me, this looks like it could be in a flood insurance. Flood insurance or floodplain, excuse me. Flood insurance is not cheap, you guys. And if flood insurance is more than they can afford and it's required, we're not getting loan approval. I'd rather find all this out while I'm still in due diligence. So the least I can do is get my buyer their earnest money back. Most of our FEMA map looks for a 100-year floodplain. That does not mean that this floods once every 100 years. Do not let the name fool you. Somehow, I don't know why, but somehow the 100-year floodplain, if it's in a 100-year floodplain, it tells FEMA that there's a 1% chance that it'll flood every year. A 100-year floodplain means that there's a 1% chance of annual flooding. This is a FEMA map of Winston-Salem. This is Salem Parkway. This is Stratford. This is Knollwood. If you're familiar with Center, all this, or Winston, all this is over here is Thruway Shopping Center. Across the street from Salem Parkway, this is all residential up through here. And we can see in this residential area are our flood zones, our floodway. If I was assisting the buyer in purchasing this property, my flag would go up whether or not we could be dealing with flood insurance. Again, I'm not the expert, but I can look at a map and say, that's close. Let's talk to the insurance company. Especially if your buyer's about maxed out on their allowable monthly payment, I'm telling you, flood insurance will tip them over the top. We can look at the map and have this discussion before we ever present the offer. And if your buyer says, no, I'm maxed out, I can't afford it, then we need to move on. This isn't their property. So again, broker's hat back on, wrapping all this up. What's this mean for us? The location of a property in a flood zone is a material fact. Listing agents, when you list a property in a flood zone, you must disclose it. I'm not saying you have to pay flood insurance. I'm just saying that it's in a flood zone, and that's a material fact. And one of the best things we can do as brokers, especially when working with our buyers, is look for possible flood zones. Streams, creeks, rivers, lakes, ponds, the ocean, depending on where you are. We all sat here brokenhearted and helpless as we saw what happened a month ago in Western North Carolina. They were not prepared for this, and y'all, many people didn't have flood insurance because it's the mountains. The mountains never flood. Did y'all see those videos? It was one of the hardest things I've ever witnessed. Those rivers turned into landslides and mudslides. Now, I'm not saying we can predict this. We can never predict it. But when you see a river, there's a chance that it could flood. Does that make sense to you guys? I'm not saying this is in a flood zone, but I'm saying, hey, look, there's a body of water. Let's look into it. Also for brokers, as we've said, listing agents with homeowners insurance, we need to have our sellers keep coverage until that deed records. It is still theirs. If the house burns down before it's recorded and the seller doesn't have coverage, they're in a bad place. Buyer's agents, we need to have our buyers shop around for their new homeowners insurance policy while we're still in due diligence to make sure they can afford it. Make sure that it'll be allowed per their monthly payment, their approved monthly payment. Have the conversation about flood zones, and not flood zones, I'm sorry, homeowners insurance with both parties, no matter who you are, listing agent or buyer's agent. And that is Unit 13. Again, we're not spending all of our study time here. I would just focus on the PowerPoints that we just went over, as the PowerPoints come from the syllabus. And if we know what's in the syllabus, we're prepared for our state exam. Questions on Unit 13? So I need to stop sharing just for 1 second. Up next, we're heading to 18, which is on page 488. Again, not a heavily tested unit. I say between these three, you can expect to see a test question. So we're not going to spend all of our study time here, but I do want to go over it so you guys have it so we can get you that test question. In Unit 18, we get to put on our accountant's hat. We're wearing lots of hats. And in Unit 18, we're going to put on our accountant's hats. I'm not giving you accounting advice. I'm not a CPA. Stay in your lane. Even if you do your own taxes every year on Turbo Leads, good for you. But you still don't have the authority to tell somebody else about taxes. Only CPAs, only accountants can give advice about taxation. So when your buyers or sellers start asking a bunch of questions, unless you're an accountant, make sure you send them to the accountant to discuss. And this section is broken down into 2 sections. So first, we're going to talk about the tax benefits of homeowners insurance. And we're going to, I'm sorry, not homeowners insurance. We're going to talk about the benefits of homeownership. And we're going to look at those itemized deductions and adjustments. We're going to break this down into 2 different categories in just 1 second. And then I know that word says calculate, but we're not actually going to pick up a calculator. So we're going to define adjusted basis, amount realized, and capital gain. And then we're going to put those words and show you how they work in a formula. I say no one or the other. Either know what the word means or know how the formula works. That'll get you through that question. Some of us are math brains, others are vocabulary brains. So I got 2 different options here for you. So the first section, the first category, tax benefits for personal residents. If you own your home, maybe you pay taxes, maybe you make a mortgage payment, mortgage and interest, principal and interest. As a homeowner, you may be eligible for some tax deductible expenses. I don't know. Get with your accountant. The interest that you pay every year to the bank, PITI, principal and interest, that interest may be a tax deductible expense. Talk to your accountant. Discount points are prepaid interest. So because it's interest, the year you buy your home, discount points might be the tax deductible expense. If you have a prepayment penalty, you may be able to get a tax deduction. Any of your insurance premiums, homeowners insurance, flood insurance, may be eligible for tax deductions. And then again, the year of closing, your loan origination fee. Whenever you work with buyers, specifically, advise them, especially their first year of home ownership, to talk to an accountant. Make sure they're taking advantage of these tax deductible expenses. After that first year, homeowners may also be able to apply their real property taxes, the annual real property taxes, to homeowners insurance. Again, I don't know. Talk to your accountant. So tax benefits for personal owners, people that live there, people that occupy the property, is one category of taxes. There's also the category of when you sell that real property. So tax considerations when selling, listing agents, make sure your seller talks to their accountant the year that they sell to take advantage. Capital gain is the amount realized from the sale. Capital gain is what you put into it, what you paid for it, what you put into it versus what you sold it for. And the difference is your capital gain. Cost basis is your initial cost. Cost basis says, what did you pay for it? Capital improvements are improvements on the property that add value. Painting a room is not a capital improvement. Finishing the unfinished basement is a capital improvement. You've added value, you've added square footage. The cost basis and the capital improvement together equal the homeowner's adjusted basis. So the adjusted basis is what you put into it, what you paid for it, plus capital improvements while you owned it. And together the two equal your adjusted basis. The amount realized is what you sold it for. We're going to see all these words put in a formula in just a second. Again, some of you do better with the vocabulary. Pages 488 to 489, knowing what the words mean. Others see it better played out in a formula. So we'll see that example in just a second. When you're selling real property, those that are available or eligible for capital gains, there's an importance that we understand short-term ownership versus long-term ownership. Short-term ownership is the one that owns it 12 months or less. Long-term ownership are those that own it more than 12 months, more than a year. Typically speaking, the short-term owner is the investor or the flipper. They're not eligible for capital gains because their taxes, their income is on the income of selling the investment property. They get tax breaks on what they put in to flip it, what they paid for it, what it costs them to flip it, what they turn around and sold it for. That's just their cost of doing business. So specifically what we're talking about with tax consideration when selling, we're focusing specifically on long-term ownership, which means those that have owned it for more than 12 months. In order to qualify for capital gains, long-term ownership, the principal, first off, it's got to be your principal residence, which means this is where you lived most of the time, 2 out of the last 5 years. And those 2 years do not have to be consecutive. For capital gain taxes, they may be able to offer you an exclusion. If you're a married couple filing jointly of your capital gains taxes, you can get up to $500,000 tax-free. If you're single or married filing separately, you could be up to $250,000 capital gains tax-free. And again, when we put all this in a formula in just a second, we're getting ready to see this played out. So let's take those words that we just defined and let's put them in a formula so we can find your capital gains. The adjusted basis is what you paid for it. When you bought it, what was the purchase price? Plus any allowable closing costs, plus those capital improvements. So we got our cost basis plus our capital improvements. The cost basis is what you paid for it when you bought it. The cost basis plus your capital improvements gives you your adjusted basis. It's what you put into it when you bought it, once you put into it during the time that you owned it. So we have our adjusted basis. Fast forward to when you sell it. When you sell it, the amount that you sold it for minus your allowable closing costs gives you your amount realized. So the adjusted basis is what you pay for it, what you put into it. The amount realized is what you sold it for. The difference in the two is your capital gains or loss if you didn't sell it for what you put into it. So your amount realized minus your adjusted basis is your capital gains on the sale of this property. So let's put this in a formula. Let's look at an example. Put your pencils down. Look at an example with me. I got an original purchase price of $398,000 with $1,500 in closing costs. 20 years later, we sold it for $920,000 with $600 in closing costs. So the first thing we have to do is find our adjusted basis. The cost basis is what we paid for it plus our closing costs. And this homeowner didn't do any capital improvements. So we don't have an adjusted basis. If I had capital improvements, then we would have an adjusted basis. But this person didn't do anything but paint and put new carpet in. They didn't do anything to add value. So all we're looking at is our cost basis, which is what you put into it when you bought it. Now, fast forward 20 years, you turn around and sold it for $920,000, deducting your allowable closing costs, which gives you your amount realized. The difference in the two is this homeowner's capital gain. So during the 20 years they owned it, they have a capital gain of $519,850. Let's say that this homeowner is married filing jointly. There's that tax exemption of $500,000. So we take our capital gain minus that tax exemption, which means you're not going to be taxed on $519,850. $500,000 is exempt. So your taxable capital gain is $19,850. I'm not an accountant, so I'm making numbers up. Let's pretend that the tax rate this year is 15%. 15% of your taxable capital gain is how much you will have to pay in taxes for the sale of this property. If you're single or if you're married filing separately, then this number is $250,000. And that's what we saw on the previous slide. Accountants may be dealing with special rules. The home office gained in popularity at the onset of the pandemic. If you have a home office, there's a portion of your home that might be eligible for home office tax benefits. So you might be able to write off some of those office expenses. Talk to your accountant. In Unit 10, we talked about an installment sales contract. We said with an installment sales contract, the buyer's paying the seller for the purchase price, but they're not doing it in one lump sum. They're doing it in installments. The homeowner collecting those payments in installments may be eligible for tax benefits. And then if you have a vacation home, that's another special set of category, another special set of rules, I should say. You may be able to write off the vacation home as a vacation property. Some expenses to maintain the vacation home might be a tax deduction. Again, talk to your accountant. There's rules with all three of these. So your accountant can go over the rules and see if you qualify for these tax benefits, tax deductions. Tax deferred exchange, also known as the 1031. This is for investors. Tax deferred exchange program is for investors. This is a program from the IRS that will allow an investor to sell an investment property, take the proceeds of the sale of that property, and use it to purchase another investment property. So it's a like kind exchange. You're exchanging investment property for investment property. And because you're partaking in this tax deferred exchange, the IRS will allow you to defer from paying capital gains taxes on your investment properties. As long as you're using the proceeds from this sale to purchase another type of property, you can defer paying those capital gains taxes. There's rules in place. Get with your accountant. And understand when we say like kind exchange, it's property for property. So it doesn't need to be condo for condo or anything like that. It's the sale of one investment property used to purchase another. And so you might be able to defer paying some of those taxes by taking advantage of the IRS program 1031. Accountants also set a depreciation schedule. So depreciation, we said in Unit 17, was a loss in value for any reason. And accountants can help homeowners set up a depreciation schedule to help them determine how much is going to be lost. How much are we losing each year? And the most common way to do it is a straight line depreciation, which just says, let's say we determine that this building has value, I'm making numbers up, for 50 years. And this property is worth, I'm going to make some big numbers up. It's worth $3.5 million. So the value today is $3.5 million. What the accountant's going to do is take that $3.5 million and divide it by 50, because we determined that's how long it offers value. So take 3.5, I divide it by 50, and I get $70,000. Straight line depreciation says each year for the first 50 years, it's going to depreciate by $70,000. Every single year, it loses $70,000. So year 1, year 3, year 26, year 49, we depreciate $70,000 until we maximize its useful life of 50 years. This runs very parallel to the cost approach that the appraisers take when determining value. I'm sorry, not the cost approach. Take that back. Income capitalization approach. Income capitalization approach looks at this straight line depreciation to determine how much value we're going to lose each year. And that's Unit 18. Count hat off. Again, we're not spending all study time here. But if you're watching this recording right now, at least hearing it could get you that test question, should it come up on this unit. And the only other thing we have left to say is unit 16. I hate to say it, but this is one of my favorite. I do wish we could spend more time here, but we're doing what the syllabus tells us. Unit 16 is our basic residential construction. We're going to go build a house in this unit. Note the word basic. Also note the word residential. Commercial tends to be constructed differently than residential. Commercial tends to be built differently than residential. So we're just going to focus on residential construction. We're going to talk about some basic architectural types of residential construction. And then we're going to briefly identify certain components of the home and the framing. So first off, some common architectural types that we might see in residential, and this isn't all of them, but this just gives us an idea of some different styles, some different types. In North Carolina, most residential properties are wood framed. Wood is cheaper. It offers flexibility. It's easier to insulate. We also know that termites like wood a whole lot. So these wood frame construction properties, the wood is often treated to try to prevent termites at the beginning. Termite control is something that should continue for the property to keep the little buggers off. Ranch style properties. With a ranch style property, all of your main living level is all on one floor. So your kitchen, living room, dining room, bedrooms, bathrooms, all of your main living level is one floor. You might have a basement with a ranch, but you don't have to. In a split level, you have some of your main living on the main level. So this, where you walk in the front door, you'll probably have your living room, dining room, and kitchen on the main level, generally. And then at some point, halfway through the home, it splits. So you're presented with two staircases. If you go up on the second story of the split level, generally speaking, is where your bedrooms are. When you go down, you might be in some below grade. And generally, this is your bonus room, maybe a den, family room, laundry room might be down there. Don't confuse a split level with a split foyer. A split foyer is a two-story home. But with a split foyer, you walk in the front door and you got two choices. You either go upstairs or you go downstairs. Split foyer. The two-story home then, generally on the first floor, you're going to have your kitchen, living room, dining room. Maybe your owner's suite is on the first floor. And then on the second floor, you'll have the rest of the bedrooms. Again, maybe the owner's suite is upstairs. And then your contemporary is a more unique design, oftentimes custom built. Of the four of these, interestingly enough, of the four of these, in general, looking at cost per square foot to build, cost per square foot to build, in general, the ranch will be the most expensive per square foot because when you're building, the two most expensive components are the roof and the foundation. And with the ranch, everything has to fit under the roof and sit on the foundation. At least if you have a 2-story, we can take that ranch and split it in half. So now we have half the roof and half the foundation. Same square footage in some cases, but we just split it. So the more roof, the more foundation. Generally speaking, the more expensive cost per square foot. So let's talk about some basic building components. Don't get overwhelmed with this. This is just showing us everything that we're getting ready to talk about. We're going to break it down into different sections and talk about the different components. And like builders, we're going to start from the bottom and build our way up. The bottom being the foundation. The first thing they do is put in footings. They're going to dig out like a trench for the footings. Footings need to be below the frost line to allow for the earth to expand and contract as the weather gets super cold. The further north you go, the deeper the frost line. Footings are generally, again, dug trenches. Pour concrete into the trenches. And then on top of the footings, we build our foundation. A couple different types of foundation that we'll talk about next. The foundations rest on the footings. They offer support for the whole property. Maybe foundation is what we're looking at as brick. Maybe cinder blocks, poured concrete. If your foundation is a crawl space or a basement, it's not uncommon to see piers. Piers just help offer support. Not enough piers, you may have a sagging floor. Sagging floors are not always bad, not structural issues necessarily. If there's concern over a sagging floor, let's get a structural engineer in here. Different types of foundations. The crawl space lifts the living level above the ground. It allows for ventilation and moisture control. We can do preventative pest treatment. We can get under the home. A basement is a story high crawl space. Basements are just dug in a little bit deeper. They're a story high. Maybe they're finished, maybe they're unfinished. And then a slab, the home is built directly on a concrete pad. So we put the footings down, and then on top of the footings, we just pour concrete. That creates a slab, and build the property on that. You have nothing underneath. Buyers tend to have preferences about what type of foundation they prefer. So this might be a good question in your buyer consultation and helping them find the best home for them. What kind of foundation do you like? Do you want to be on a slab? Do you want a basement? From the foundation, we start building up. Girders they rest on top of piers. There's those piers in our foundation wall. Girders just help offer support. We want things to start level, understanding that settlement just happens. Homes settle as they age and weather the elements. But the girder just allows us to start with a nice even floor, nice even surface. Sill is part of the floor framing. It is the lowest horizontal piece of wood. So it just helps offer support. Again, help with that level. On top of the sill or the girder is the floor joist. Joists just connect the foundation to the subfloor. Subfloor goes on top of the joist. Subfloor is usually plywood, particle board. Our flooring goes on the subfloor. So our carpet, tile, laminate, wood flooring rests on the subfloor. If you've ever pulled carpet up of your home or pulled up the tile, you're eventually going to get to some particle board. That particle board is your subflooring. Now that we have our floor framed, we can start building walls. Studs are the vertical pieces of lumber that connect the floor to the ceiling. Building codes have changed over the years on studs, the size, the weight, how far apart studs have to be. Today, they need to be at least 16 inches apart. Older homes may have had another building code when they were built. The sole plate connects the stud to the subfloor. The top plate connects the stud to the ceiling joist. The ceiling joist provides support for the roof. Headers. When you're framing a home, when you're putting the studs up, some holes don't look the same as others. There's got to be places for windows, doors. So those openings in the studs are going to have headers on top. These are just horizontal pieces of wood that help support that open space until we can get the windows and doors in. So it offers support for that open space where windows and doors will go. Different framing systems. Platform is what we see the most often. It's the most common. Platform framing, each floor is framed separately. So you have joists that go from the floor to the ceiling on the first floor. I'm sorry, studs that go from the floor to the ceiling on the first floor. And then you have studs that go from the floor to the ceiling on the second floor. Each floor is framed separately. Balloon framing is for usually for 2-story homes. And framing is from foundation to ceiling. Those pieces of wood, those studs, are the entire length of both stories. And then post and beam is it uses a different type of lumber, usually a bigger lumber. With post and beam, I tend to think of like mountain cabins, Thomas Kincaid houses. When you walk in and you actually see the posts, just bigger pieces of lumber. Just give it a different style, a different look. From the walls, we go on up to the roof and the ceiling. Again, ceiling joists are placed on top of the top plates. They carry the weight of the roof. They offer support for the roof. Rafters is the part of your roof, the sloping members of your roof. So what we see a lot in this area, North Carolina, it's kind of that triangle shape. Those are your rafters. Gives the roof its shape. The ridge board is the highest piece of construction. So the ridge board pops up a little bit and hopefully it helps direct water down the rafters. The water from the rafters hits the gutters. The gutters direct the water away from the house. Water in houses, not good. We want to do a big part of what we do to construct is to keep that moisture, keep that water off the house. Eaves are the piece of the roof that kind of jut out from the home. So we're looking at our eave here. Eaves have a couple different components. The soffit, if you would go outside and stand with your back against your home and look straight up, you're looking at the soffit. Usually has a bunch of little holes in it, helps offer ventilation for moisture control. Fascia board is what we attach our gutters to. So the fascia board goes at the end of the rafter. Once that fascia board's on, we can connect the gutters again to help draw rain and moisture away from the property. And then the frieze board is that decorative piece. Maybe makes the home look a little pretty, but also can prevent the elements from hitting the home. Now that we have our floor, wall, and ceiling framing, we can start putting up exterior walls. Sheathing goes on the studs. Again, sheathing is often particle board, plywood. On top of the sheathing is some kind of tar paper, or what we're seeing more often today is a house wrap. And this is what we're looking at here, is a house wrap. Goes on the sheathing. Try to protect the sheathing from the elements. And then on our house wrap, we put our exterior siding. So vinyl, brick, stucco, stone, whatever your exterior siding is. For our exterior walls. Homes have windows, a couple different types of windows. In sliding windows, a piece of the window moves. So either you have a piece, a sash that slides up, or maybe it's vertical from side to side. Swinging windows open out. Usually there's an awning over them. They usually have a crank that cranks them out. Then when you want to close them, they close back in. And then fixed windows don't open. They're picture windows, usually so we can see the view. That's what we're looking at here, is a fixed window or a picture window. Components of windows. The window sill is the bottom of the window. The window sill is the bottom, maybe even a ledge or something. The window jamb are the sides. And then the header is the top. Think of where your head is. Your head's on top. If your window moves, the piece that moves is the sash. And then muttons and mullions are the cross hatches of the window panes. So muttons are your horizontal hatches, mullions are your vertical. homes also have doors. Different types of door. Your exterior door is going to be different than your interior doors. Most interior doors are hollow, easy to kick in. We want your exterior door to be solid, usually a different product, a different type of wood. That makes it harder. Whether exterior or interior doors, a flush door is a smooth finish. Panel doors are what we're looking at here, kind of raised pieces, gives it just a little nicer look. Sliding glass doors often lead to a patio or a deck. The door is often window, clear. Slide it open and walk on through to your patio. And then French doors are more often associated with your upscale properties, your higher end properties. French doors offer a decorative door. Usually they have glass panels, maybe crystal knobs, and they might lead, for example, from the kitchen to the formal dining room. Good news, the components of the door are the same as the window. So the bottom is your sill, the sides are the jamb, and your header's on top. Back up to our roof. We put the rafters down, which gave it its shape, its slope shape. On the rafters go decking. Again, some kind of plywood, particle board. On the decking, we put roofing felt, which is some kind of tar paper, something sticky. So then we can attach shingles to the decking. Shingles are usually like AstroTurf or asphalt. I'm sorry, not AstroTurf. Shingles are often asphalt or fiberglass. But one thing we can know for shingles, they're laid in a certain way to allow water to flow down. So they're laid to allow for water to go down into the gutters and away from the property. The pitch of the roof is the slope of the roof. Rise over run. Some roofs have more of a pitch than others. May come down to the builder, how they build, may come down to the buyer if they're custom building. In the attic, and sometimes even in the walls, we're going to have some kind of insulation. Old school insulation are the rolls. You get a roll of insulation, just kind of roll it out. The Pink Panther is doing foam insulation. So spraying the foam in, and then it hardens or fill, and then it hardens and provides insulation. You could also have foam. Seeing this being more used in more and more in construction. Weather stripping is used to seal windows and doors. So if there's any air leak, weather stripping can be used to seal that. It's not only good for your energy bill, but it also helps keep pests out. So if you see daylight coming through any part of your door, consider weather stripping, or else you're inviting unwanted pests. And then again, the big thing with home construction, a big thing to always keep in mind is moisture control. Proper ventilation. This is why we have little holes in the soffit to allow air to flow. Some basements and crawl spaces use a vapor barrier now to keep the moisture in the ground and not allow it to come up through the property. Moisture and the home are not good. Our North Carolina Uniform Residential Building Code has certain levels of insulation to use. Insulation is measured as an R value. And today, the building code, the higher the R value, the more resistant to heat and the elements it is. So you're going to have a higher R value in the ceiling because the ceiling's the one that gets, the roof is the one that gets all the elements. It's got the sun beating down on it all day. And we don't want the heat from the sun to come into your home. That just makes your AC run more than it needs to. So ceilings have a higher R value. If you go up to the mountains, there may be higher R values because they have more cold temperatures. We got heating and air conditioning systems in homes. The most common today that we're building with is the HVAC system. HVAC stands for heating, ventilation, and air conditioning. So the HVAC system is a one and done. It combines everything, does everything. The HVAC can run on oil, electricity, however it's set up. Some homes, especially older homes, may not have an HVAC. This is fairly new in the big scheme of things. So older homes may have separate heating and air conditioning if they have air conditioning. So some separate heating systems. The central forced warm air is what we see in our HVACs. This just uses heat pumps and pushes the heat and then cool through the ductwork. Gravity warm air, there's no duct system. There's a central furnace smack dab in the middle of the house. That furnace heats the home. Older homes may have electric baseboards. They run along the baseboard, plug in, and they generate heat. Space heating systems, again, in older homes, you may have kerosene heaters, radiators. And then gaining in popularity today is our solar heating system. You may have solar panels on the property that is capturing the heat from the sun to heat the property. You may also come across solar farms. There's a huge solar farm in Winston out Clemens Road. It's capturing heat for a certain area or a neighborhood or community, more than one home. If heating systems can be separate, so can AC systems. Central forced air is again using our duct system. But you may have room air conditioners, you may have window units, window AC units to help cool the property if it's not centralized air. Back to our HVACs, they're going to have a heat pump, which again is a combination of heat and air. You turn it one way to pump heat into the home. I think that's right. And then you flip the switch to pull heat out of the home that cools the home. Heat is measured in BTUs. British thermal units. And we don't need to know much about that, but what we do need to know is that each HVAC system heat pump can only push so much heat and air around. So as the capacity of the system is designed for the size of the home. And one thing we know is that heat rises. And it's not uncommon in construction today for a two-story home to have heating or HVAC systems on the first floor and the second floor. The first floor unit is generally bigger, but then we can regulate the second floor. So all that heat in the first floor isn't rising, help save on your energy bill. When you're showing property, there's two things to look for. One, you're going to see two units outside, one's bigger than the other. But another thing to look for are the thermostats in the home. If you got a thermostat on the first floor and a thermostat on the second floor, you have a dual heating, dual HVAC. Builders are regulated by governmental regulations. For example, we've got the North Carolina Uniform Residential Building Code. Building codes just set the minimum construction standards for safety. So building codes come in and say, look, builder, you can build this house however you want to, but you got to do at least this. We got to protect the people. We have to be safe. FHA and VA loan products will have different property requirements under HUD's minimum standards. So with FHA and VA, or government-backed loans, not only do the people have to qualify, but so does the property, as HUD has different standards than building codes. Building codes are state, HUD codes are federal. FHA, VA properties. And then the contractor license, this is just our general contractor. Usually general contractors involved in construction and any major renovations because they're coordinating between all the people involved. So if you're building a home, you're dealing with the concrete guy, the siding guy, the framing guy, the electrician, the plumber, the structural engineer. When you're building a home, you're dealing with those different people, and the general contractor can coordinate it. Who's supposed to come out, when, and do what. Things have to happen in a certain order. General contractors are going to usually be responsible for ordering permits to make sure a thing is built in compliance with building codes. And that's it. Whole bunch of words in Unit 16. I know if you're going to review anything in 16, again, we're not spending all of our study time here. But if you're going to review anything in 16 before your exam, I would just flip through those key terms real quick. Have a very basic understanding of what those words mean. And then for any of these units, 13, 18, and 16 that we just blew through, I'm going to recommend the key point reviews for all three of them, the Cliff's Notes. Keep it simple, keep it basic. And then your student quiz. And that's what we got. Does anybody on the call have any questions? If you're watching the recording, if you have questions, you can reach out to me, of course. Does anybody on the call have any questions? Still on? Y'all know what I know. You have everything you need to get you through our end of class exam on Thursday, get you through your state exam whenever you apply and go. Remember, I'm always here to help. Even though you and I may be done on Thursday, I'm still here through your journey. So let me know if there's anything I can do to help while you're preparing for that state exam. Let me know if there's anything I can do to help while you're preparing for our end of class exam on Thursday. Have a great rest of your day. Have a good day tomorrow. Showtime Thursday morning. We'll see you guys then. Thank you.